Good evening, everyone, and welcome to the first meeting of the Board of Adjustment for the month of August. Excuse me. We have a relatively what looks like a light agenda this evening. Let's hope that proves to be the case. We have 6 members this evening, and as everyone, that constitutes a quorum, as everyone knows. If we have a question where there's only 5 voting members, I will go through this again. But the rule is that we make an offer to the whoever the applicant is to postpone or proceed this evening. So that's entirely up to you. So just in case that comes up this evening, just let me announce that right now so you can be thinking about it. The ground rules are pretty simple. We read the legal notice of what the issue involves. We ask for the applicant to present the case to the board using 15 minutes or less. If more is needed, we ask the applicant to request an additional 5 minutes before they begin their speech or presentation. And then following that, questions from the board, if any. Following that, we have speakers who are in favor, 5 minutes. Speakers who are opposed, 5 minutes. Speakers who are for or against, with no time limit at all, other than, and if you've spoken earlier, you can come up again. But we ask that people obviously be considerate of everybody here's time and speak directly to the key points of the question at issue before the board. So, having said all that, the first item on the agenda this evening is the approval of minutes for the meeting of July 19th, last month, 2022. Is there anyone who has a change, a correction, or an addition to the board? Mr. Mantle?
No.
No? Ms. Margison?
Yes, I have a change. On page 2, the first full paragraph, Ms. Margison said the abutter Pike Industries submitted an option. I said motion. And on page 4, the first paragraph underneath discussion of the board, at the very end, I say that she said the fact that the building was in the historic district, not just district, and also was an extra purpose that the board needed to consider when it entertained a variance. And that's all.
Okay, thank you. Anybody else? Anything further or not? Is there a motion to approve the minutes as amended by Ms. Margison's comments to clarify? Anybody? Mr. McDonald, thank you.
So moved.
Second? Who's got the second? Mr. Lee. Okay, thank you. Those in favor of the motion to approve with the amendments changed, please say aye.
Aye.
Aye. Thank you. All right, all done. We do have a couple of items under old business this evening, and the first one is a request to postpone, and it is for the property at 108 Burkett Street. And I don't think I need to read the whole addition, but it's with respect to a garage, and the request is to postpone it. Is there a motion from the board to that effect?
I'll make a motion to postpone until September.
Thank you. Second to that?
Second.
Second, Mr. Lee, thank you. Mr. Mantle, your motion, please.
Common request, have no problem postponing it until September.
I agree.
Thank you. Those in favor of postponing this item until September, please say aye.
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 Any opposed? None of. Thank you. Done. All right. The next item and the last item under old business this evening comes under the situation that I just mentioned a few minutes ago, where if there are only 5 voters, the applicant is given the opportunity to postpone. And this is the case here. And it's the request of Jeffrey M. and Melissa Foy, owners, for property located at 67 Ridges Court. So, excuse me, is the The reason for that rule, obviously, is that regardless of the situation, 4 positive votes are required to pass a motion, and if there's only 3 people, you've got to get 4 out of the 5. Excuse me, if there's only 5, you have to get 4 out of the 5. So, does anyone have any other comments on this one? Okay. Would you introduce yourself and explain the situation as to whether you want to proceed, please?
Yes, thank you, Mr. Chairman, members of the board. I'm Tim Phoenix from Hopeful Phoenix, Gormley and Roberts here in Portsmouth, here with and on behalf of Jeff and Melissa Foy, who are seated in the front row. Also with me is John Shagnon, who's done the technical work, Robin Valeri, a realtor who will speak, and Peter Stanhope, our appraiser, who should be on Zoom and speak. I've conferred with my client while you were going through that, and they prefer to go forward with 5.
Okay, very well. In that case, I'll go ahead and read the announcement, and we'll proceed with the hearing. Okay. It reads as follows. The request of Jeffrey M. and Melissa Foy, owners, for property located at 67 Ridges Court, whereas relief is needed to construct a 718-square-foot garage addition with living space and deck above, which requires the following. 1, a variance from Section 10.521 to allow a 15.5-foot front yard where 30 feet is required. 2, a variance from Section 10.321 to allow a non-conforming building or structure to be extended, reconstructed, or enlarged without conforming to the requirements of the ordinance. Said property is located on Assessor Map 207, Lot 59, and is located within the Single Residence B SRB district. And who speaks for this proposal, please?
Thank you, Mr. Chairman. Again, Tim Phoenix from Hopeful Phoenix, Gormley and Roberts. I've already introduced my team. Mr. Chairman, does the board prefer to deal with the other request for postponement that's in the new business before going forward with this?
No, I think we'll stick with the regular agenda this evening. Thank you.
Okay, thank you. Peter has up on the board the site plan. This is the existing conditions site plan. And you can see the house there that's sort of in the center of the screen. It's on the right side as you're facing Ridges Court. The lot is 16,500 square feet. It's the very end of Ridges Court on the left as you're going down, and it has fronts on Little Harbor as well. There's a 1 3/4 story home on it. You have renderings of those and photographs with a 1,591 square foot, 3-bedroom, 3.5 bathroom Cape Cod style home. There's also a detached shed on the site, and a dock leading into Little Harbor, and 2 driveways on the property. Most of the lot is in the 100-foot tidal buffer zone. A corner of the existing home and one of the driveways is also in the tidal buffer zone, which means we will be going to the Concom and Planning Board for conditional use. If you can go to the next page, Peter. So this is the proposal. You can see at the bottom of added on to the back of the house or the side of the house on the right side as you're facing it is a 718 square foot addition. On the first floor, you have renderings from the architects. It shows there's going to be a 2-car garage. The owners have 3 cars normally, and sometimes an additional car when one or both of their daughters are home. Above that is going to be living space and deck space towards the water. And then above that, they're converting the new area into a master bedroom suite. So that's what they're doing. It's pretty simple. Right now, the existing home is 13.6 feet from the front lot line. This is going to be an addition that's about 15.8 feet, so a little more 2 feet set back from the front of the house. If you read the staff report, you would note that back in about 20 years ago, a then owner got a variance to put a front entry 8.1 feet, and before that, a addition onto the old dwelling of 9 feet. And I ask you to keep that in mind, what would have been there if that hadn't come down, because that is even closer yet to the lot line. Because what this is coming down to, as you know, is concern of some of the neighbors, notably the 2 closest across the street, that their views are lost and therefore their property values are diminished, which we heartily dispute, but it is something to keep in mind. The proposal meets all other dimensional requirements except expansion of a nonconforming building and the setback. And of course, if you're going to put an addition on a house, you have to put it on where the house already is. And what as I've explained what they're adding living space, it's expanding a living room, adding a deck with a trellis over it, garage down on the bottom floor, and then a bedroom up above. And the only way that all works is if you make the addition connect to the house in a way that makes it work. If you were to set the addition back to the 30-foot requirement, then it doesn't work to expand that living space. It's all off kilter. So that's the program. And unless you have any questions about what we're doing, I'll go right into the variance requests or requirements. Seeing nothing, I'll go forward. So the first two, as I always do, is that the variances are not contrary to the public interest, and the spirit of the ordinance is observed. I won't go through the whole thing, but the test under the case that I always cite is, will granting the variance unduly and to a marked degree conflict with the ordinance such that it violates the ordinance's basic zoning objectives? Mere conflict with the ordinance is not enough. And the case law in dealing with those two requirements comes down to, will granting the variance alter the essential character of the locality, or will it threaten the public health, safety, or welfare? And Peter, if you can go to the tax map, this is, I think, Exhibit C or D or something. And while I'm looking at this, I assume you did get and receive and have time to review the submission that we did yesterday with a cover letter from me and an opinion of our realtor and Peter Stanhope, our appraiser. Is that accurate?
Yes.
Thank you. And I apologize for the late notice. It just took some time to pull it all together, and I got it to you as soon as I got it. So the reason I'm asking Peter to put up the tax map, and you can see the lot there outlined in bluish green, is that on this tax map there are numerous lots in this area that have buildings that are on small lots, are too close to the lot lines, are too close under current zoning to the frontage, et cetera. Also noteworthy is that virtually any lot along that has waterfront has homes behind it whose views are blocked by the home in front of it. It's a common thing, and our proposal and our position with respect to the concerns of neighbors who claim to lose views is that when you have a view across someone else's property and you do not have a view easement, you do not have a right to that view. In fact, counsel for one of the neighbors even admitted that. That means that the view may not always be there. So the value of the property, baked into the value of the property, is the knowledge that that view may not always be there. I'll have my experts expand upon that shortly. The other thing to keep in mind, and this isn't a proposal that's going to happen, is that any current owner or former owner could have planted a vegetation that would block the view. There's no intention to do that. The point is that that possibility is included in considering the value of someone else's property that has a view. Again, that view might be lost. So turning back to those first two variance requirements, the addition will not alter the essential character of locality. As I mentioned, 20 years ago or so, variances were granted to put a home about 9 feet away from the street side property line. And as I mentioned, there are numerous homes in the area that are large homes, small homes, some large lots, many small lots, many homes on very small lots that are close to property lines. So this lot and this variance is within the character of the locality and does not alter it. Similarly, it's not going to threaten the public health, safety, or welfare because It's going to be a two-code addition. It's going to allow the owner to get a better use of their property as they want to use it. It's expensive property, as you know, the waterfront property is in Portsmouth. Given those facts, neither the public health, safety, or welfare is threatened by a variance which puts an addition 2 feet behind the house that's already there, nor will it alter the essential character of the locality for the reasons I've stated. The third requirement that I usually go through is the diminishment of property values. I'm going to skip that one for right now and other than what I've said, let my experts deal with it. I've mentioned a couple of issues with respect to that already. The fourth is that a denial of the variances results in an unnecessary hardship. And again, remembering that we meet all of the dimensional requirements of the ordinance except the setback, which we really can't change because that's where the addition needs to go to connect to the existing living space the way they want it to. So the fact that half the property approximately is within the 100-foot wetland setback and the house is already there creates special conditions. The second prong of the hardship test is that there's no fair and substantial relationship between the public purposes of the ordinance and its application in this instance. Why do we have setback requirements? It's to prevent overcrowding and overburdening of land, to improve sight lines for pedestrians and motorists, ensure adequate air, light and air circulation, and sufficient area for stormwater treatment. Well, as I mentioned at the outset, this lot is 16,500 feet, so meets the requirement. There's plenty of area for stormwater management. It's at the end of a street. There's nothing between it and the water. So you can see past it. Pedestrians and motorists who are driving up and down the street or coming in and out of driveways can see past it. No one is negatively affected by air and light. So there is just no reason to apply the strict requirements for a 30-foot setback for this addition. The third prong of the hardship test is that the proposed use is reasonable. Again, the case law is if the use is permitted, then it's deemed reasonable. It's a residential use on a residential lot. This area, the zone it's in calls for approximately 1 to 3 homes per acre. This would come in at about 2.5 homes per acre, given its size on a 16,000 square foot lot. And then finally, substantial justice will be done by granting the variance. And as I always do, the test is if there's no benefit to the public that outweighs the hardship to the applicant, this factor is satisfied. Any loss to the applicant not outweighed by a gain to the general public, not necessarily the neighbors, the immediate abutters, but the general public, is an injustice. I've cited some constitutional law in here, and I'll read part of it. No part of a man's property shall be taken or applied for public uses without his consent or that of the representative body of the people. The property in the constitutional sense has been interpreted to mean not the tangible property, but the right to possess, use, enjoy, and dispose of it. And that's what we're asking for here. We're asking for the reasonable right to possess, use, and use our property by expanding the size of the house in a relatively modest fashion at the end of a street where it is going to take away some views of the two closest neighbors, but not all of the views. You will probably see some renderings by those neighbors, and I ask you to keep in mind that those renderings are not necessarily accurate. It depends on where you're taking the photograph from. I'll point out that some of the photograph that I've seen, which has a red outline, I don't know if that outline's accurate. They haven't been on the property that I know of, and the photograph doesn't take the whole expansive view. So balancing the owner's property rights to develop their property against the rights of people who claim a view who don't have an easement, I'd like you to consider the fact that a denial means that the owner's property is less valuable. In other words, granting the rights of someone who's claiming a view and loss of a view and therefore loss of value, if that is true, then the owner of this property loses value because he can't develop it properly the way they want. So we don't believe there's any harm to the general public. Views are maintained if people walk down the street or drive down the street. Partial views are maintained from the homes of the two neighbors across the street. So they are fairly treated, and you will hear testimony from experts to the effect that their property values are not diminished. Given those facts, To grant the variance is fair and just and reasonable, but to deny it robs the Foy family of the ability to reasonably use their property. Again, I intentionally left out any further comment about diminishing property values because I have two people who are going to speak to it. I don't know if that's part of my 15 minutes or part of their 5 minutes afterward. I don't know what the board's pleasure is. I'm probably pretty close to 15 minutes, Peter?
2 minutes and 10 seconds.
All right, so they're gonna probably take 5 minutes each. Should I put them on and go forward as people speaking in favor? Or do you want to wait and hear from others?
What's the pleasure of the board? Do you want to hear it now or later? 'Cause I don't think it makes much difference. Now.
I would prefer to hear it now.
Okay, first I'm going to ask Robin Valeri to speak, and then,
I agree.
do you know if Peter Stanhope's on?
Yes.
Okay, as soon as she is done, if you can let Peter in and he will comment, it should be pretty quick. Any questions of me before we do that?
I just have a quick question, Attorney Phoenix. How much of the project is within the tidal buffer?
John?
It would be 100%?
Yeah, the new addition is in. However, we are removing existing impervious surface would go around this building. We're putting this building on a location where it's already paved, it's already impervious. Actually, impervious surface, particularly in the buffer, is improving
Okay.
in total.
And of the existing house, is any of that in the buffer zone?
A very small corner.
Okay.
You I can't see well enough to.
I'm looking at existing conditions, I can't quite tell.
Oh, sorry. It's right there.
Oh, I see it, okay. The TB,
Yeah, you
the
can see
tidal
that,
buffer.
you can see it, the TBZ, yeah, right
Yes.
there,
And
just
it's-
that
it has
corner
to
of the
go
house, and
conservation.
I don't know what
Yeah.
that striped area is, but,
Thank you.
all right. Anything else before I turn my others loose?
Apparently not, thank you.
Hello, I'm Robin Valeri from Keller Williams Coastal Realty, and I helped the Foys buy the property last year. I just want to point out a few things. And again, he actually addressed a lot of it, but a couple things that I thought was that the opposition, the neighbors, stated that one of the lots would lose over $1 million in value. We submitted some comps. It just, there's no way. We did an amortization, even with the extra 2 parcels of land that do not have water views, her property would be valued, and again, this is just an assessment. I have never been inside her home, at 1.3. The neighbor's home, 2 houses up, granted it was 2 years ago, went for 1.135. That was 34 Ridges Court, so on the same side, less than 2 years, or approximately 2 years ago. The biggest things that popped for me was that one of the neighbors who was bringing this forth has lived there for a very long time. That's great, wonderful. She's seen this neighborhood grow. At any time in the over 50 years that she's lived here, and the property was on the market for 85 days, she could have purchased or asked for from any of the previous owners an easement, a water view easement. Right then and there, we would not be here. She never did. The other thing is that just because, and we all know this, just because you can see the water doesn't mean you have the right to that water view. The taxes kind of bring that to light. For example, the Foys, and this is an approximate, pay about $26,000 a year in taxes, and that's because they have a water view. The neighbor, and again, this is approximate, is about $11,000. Oh, sorry.
Comment.
So, I mean, the taxes alone kind of tell you that the Foys are actually paying for their water view. And they're loving it. It's got a dock, it's beautiful. And the way that it looked to me with the renderings, again, I'm not an engineer, but even if with it being designed, it looked to me as if you stepped out on, and I'm bringing the neighbor that brought this forth, her deck if you went to the side closest to the water, you would be able to see the water. It doesn't look like it's a full blockage, which is what the other Realtor had stated that it was a full blockage and that it would result in, a large number loss, over $1 million. And then the other piece that I thought was that there's no market evidence to suggest that a partial loss of a water view would result in a huge diminution of value. It just doesn't make sense to me how, your view is partially blocked and you lose $1 million, when in theory, if I was to put this house on the market, never having been in her property, obviously, I would probably, based off of what I've seen, I would list it at 1.3 max. The house that sold, a few houses, I believe 2 or 3 houses up from her, was completely redone in 2002, and I looked at the pictures, all hardwood floors, new kitchens. They stated, this was back in 2002, new electrical, new kitchen, new baths, new plumbing, new heating, and an addition of a family room. That was just 2 years ago, sold for 1.1. The Foyers paid 2.65. So, to add this on is not going to hurt anyone's property value. In fact, I think the biggest thing is that it could add to the entire neighborhood's value, because if one house goes up, the law is typically, unless your house is not well cared for, they all go up. And the other part that the attorney made a valid point, and they would never do this, but they could plant arborvitaes and block everyone. They're not looking to do that. That's not their point, nothing like that. But they could do that, and arborvitaes go pretty tall, they could block view. They don't want to do that. And the other part, when the other screen was up, on the right-hand, if you're looking at the house, if you're standing in front of it, and the water is here, on the left-hand side, there is a public walkway right to the beach. Anybody, any neighbor, anybody could literally go, up, whoop, right down, and you're on the beach. So it's not really blocking anyone's view. Anyone can utilize that. And that's pretty much my professional opinion.
Thank you. Is there any questions from the board at this point? Any questions? Nope. Thank you very much.
I just have a quick question.
Oh, I'm sorry, Ms. Margison.
So the beach that you're talking about, I took a walk down there, and there's a dock for a boat.
Yes.
Is that part of the beach, or is it?
I believe it's you own it. It is the
Public speech is that it doesn't have a dock.
Okay, thank you.
Any other questions?
Anybody else? No?
I have a quick question.
Mr. Lee.
So, yeah, we had a situation a couple of years ago where it involved a view, and I contacted a forensic appraisal firm in Minnesota that specializes in condemnations for power lines and that sort of thing. It's their opinion that the value of a view of a property is anywhere from 5 to 30% of the value. So what would you say to that?
So 5 to 30% of the value?
Correct.
That seems reasonable. I don't think that's wrong. But if you're talking, even if we marketed the neighbor's property at 1.5, I can't quickly do the math, but it's not $1 million loss of view. So, and this wouldn't be a full blockage. This would be, based on the renderings and drawings that I saw, it's a partial view. So it looks like half the house would lose the view, and then obviously the other side where you walk out onto the porch or upstairs, you'd be able to see the water. The other thing too is half the day, again, I'm not a water expert, but it's wet flat land. It's nothing that pretty to look at because the tide pulls all it out, and it's, yeah, so. Yeah.
Anybody? Ms.
Sorry,
Margison.
just occurred to me, and I may have missed this, but, so the subject lot has a water view and is taxed for that,
Yes.
correct? And what about lots 62 and 63?
I'm not certain which lot that is. Is that the
Across the street?
across the street? So it's approximately, and I don't have the exact number, but it's about $11,000.
But you don't know if they have a water view added to their taxes?
I do not, but I would assume based off of 11 and 26 that they're it is not marketed, neither property of those that you just stated can be marketed with water view easements.
But they can be taxed with a water view.
Correct, yes.
So, thank you.
Okay. I can answer that question, or I can give you an answer as I believe it. It's Jeff.
No, Mr. Phoenix, he's got the lead here.
Okay.
I told him to go up and answer it.
I didn't know the answer.
I'll have him answer it after Peter speaks.
All right. Okay, who's your next speaker?
Peter Stanhope, he's on
Okay,
Zoom.
okay. Coming in on Zoom, supposedly.
There you go. Okay. Go ahead.
Good evening. My name is Peter Stanhope. I am a certified general appraiser number 31 in the state of New Hampshire. I have practiced real estate appraisal in the Seacoast, but nationally as well for the last 40 years. I have significant experience in the question of view. More specifically, I was an expert in the Northern Pass matter and have been an expert in a case very similar to the subject where a party, in fact, bought a property assuming they had a view, only to find that a large building was built blocking their view. And that was followed by significant litigation because of the fact that it was represented they had view value. In this case, I was retained more specifically to investigate if it was probable there would be diminution in value for a garage addition to the Foy property on Ridge Court. And in that process, I took a series of steps. One of the documents you will see this evening is the Ambit engineering plan. I think it's helpful in examining that to understand the change in view. There is a series of red arrows that affect the two properties immediate to the subject across the street. And you see that their views, in fact, extend all the way to the end of Ridge Court. So we are not talking about a total loss of view. We are, in fact, looking at the possibility of a partial loss in view. That said, let's talk briefly about the view itself. The view itself, excellent, that is the example. The view itself in the photographs that have been provided to the ZBA show this beautiful water view. Unfortunately, this report was written over the weekend and I did not have the tidal mapping done until late this afternoon, and I do not have it with me here. But the fact of the matter is, half of the time we are looking at mudflats between the shoreline on this side over to Lady Isle. So we're not talking about some uniquely special view here. Going forward, I interviewed a whole series of realtors, appraisers, and municipal assessors over the question of, does an unowned, uneased view contribute value to a property? Now, I heard earlier a member of the ZBA say that they had spoken to someone who had found that views contributed somewhere in up to a maximum of 30%. That finding is reasonable for owned views as a premium to a property as compared to a property without views. And the range is actually published nationally between 1% and 30%. And so the question here is, what does these properties in questions legal description identify in their bundle of rights. And there are two key documents here for your consideration. One is the definition of market value. We're talking about the change in market value should it occur if you go forward and approve the applicant's appeal to you. Market value's definition is very clear. It assumes that the buyer is well-informed and educated to what they're buying. Now, my report includes descriptions of various views that are owned. And those are the ones who find this premium of between 1% and 30%. And they're kind of interesting from the standpoint. The first is what we call the peekaboo view, which is basically that sliver of a view which Portsmouth frequently has between two other properties, between them and the water or possibly the park. The second is the partial view, which is the interrupted view, and it can be interrupted by foliage or other buildings. And again, this is an owned view that has some premium of value. And of course, the panoramic view, which is that classic waterfront or mountaintop view, unobstructed, no risk factor whatsoever. What we all own is a territorial view. We can all stand in our front yard and look around and see, just as the two abutters can, across my neighbor's property. I can look out my window right here in Florida, I can see my neighbor's palm tree. The fact of the matter is, I am not protected from that view being interrupted. And so we as appraisers, and to realtors as well, are confronted with how do we present a property that has a territorial view to the market? And as an appraiser, can I give it a contribution to value when in fact that value can erode? It can erode naturally through the growth of the landscape. It can be blocked, as been pointed out already. And when I lived on Richards Ave, I put in arborvitaes to create privacy. They were, as I recall, 16 feet high. And I think I did not point out, I lived in this neighborhood. I lived on the corner of Fernal and Newcastle. I've appraised a number of properties, so I'm very comfortable how the market reacts to this particular neighborhood. This is a question about a territorial view. And what's fascinating here is the abutters are protected because their view continues down Ridge Court to over map 20760, where you can look out and see at high tide water and at low tide the mud flats. And what's taken away by the granting of an approval here is a very modest part of that greater view. And that sliver of land on 20760 has little or no potential of being lost because it is such a sliver. Zoning prohibits its development. There is some natural foliage on it at this point, but the likelihood is no one who owns that is going to intentionally landscape it to block their view. So what we're faced with here is, how does the market treat this situation? Discussing with assessors, appraisers, and realtors, there's always this question of, well, I can see something from the property. I think in many cases, there is not the full discussion of a territorial view and the risk inherent in it. And as a consequence, any contribution to value is minimal, if any. And I would suggest since there has been no loss of view in the case of the granting of this particular application before you, I have concluded there is no diminution in value, none whatsoever. The Realtor just pointed out a fact that is so often the case. As property values increase in a neighborhood, adjoining properties benefit by a increase in value as well. Finally, I was asked to form an opinion as to the applicant's Realtor opinion on diminution in value. More specifically, that the subject property with its current view was worth $2.3 million. Examining sales throughout the neighborhood, find no evidence that that number has any validity. Additionally, the probability of a $1 million loss, I'm assuming that Realtor was not aware that there was a view preserved, and the majority of it still is available to these properties. But even if you go back to that range of owned views of 1% to 30% and take the $2.3 million, you can't get to $1 million loss of view. So I do not find that opinion reliable. And so that is my conclusion. I'll entertain questions. I wish I could have been there this week, but business keeps me out of town.
Questions from the board, from the speaker? No? No, thank you very much.
You're welcome.
Thank you, Mr. Chairman, members of the board. I've concluded, unless Jeff wants to answer Ms. Marginson's questions, would now be the time, or do you want to wait till?
Ms. Mark, would you like your question answered now?
That'll be fine, thanks.
Yeah, please do.
Good evening, I'm Jeff Foy, the owner, along with my wife Melissa, of 67 Ridges Court. You asked a question about, was the current tax assessment reflective of the view, which is a good question. I was doing research in the neighborhood of the assessed land values, right? Because we're looking at the, when you're talking about views, you're looking at the land versus the full assessment. And Ms. Thompson's assessment for her land for 0.48 acres is $529,900, which on a per square foot basis is actually the lowest assessment for land for any property on Ridges Court. In addition, she has two, at least according to the tax maps, two additional parcels totaling 0.12 acres each, and their assessments of those two pieces of land are $18,500. So for a total of 0.72 acres, the total is just under $567,000. But in comparison to much smaller lots that are on the street, which are not far underneath that, it would suggest to me that there isn't a view assessment that's going on in the town today.
Okay, I was actually looking for an actual verification that there was a water view tax assessment on those two properties.
No, there's not actual, I know it, yeah, I don't see that. So that's all I have.
Mr.
When
Manno.
when you did your research, did you just go off the tax maps online, or did you pay a visit to the assessor, Roseanne Lentz, to get an explanation of what's on the tax map, on the tax card?
I looked at the total figures. I did not go into the office. I did it online through the Vision website that
So,
gives that information.
Whether or not they're assessed for a water view, you don't know that.
Correct. I only know what the
Okay.
total assessment is, and I know that
Okay.
that the number is not reflective of anything that was substantial.
Okay, thank you.
Okay.
Thank you. Okay.
That's all I have, other than any questions you may have and possible rebuttal.
Any questions at this point? No, apparently not. Thank you. Are there people present who would like to speak in favor of this proposal? Anyone present who'd like to speak in favor? Mr. Stith on the Zoom, anybody?
No one has raised their hand on the Zoom
All
call.
right, thank you. Apparently not. Is there anyone present who'd like to speak in opposition to this proposal? Please come up. And give us your name and address, if you would, please.
Good evening. My name is Darcy Pizer. I'm an attorney with Durbin Law Office in Portsmouth.
Pull the
You
mic
may
down.
want to pull the mic and speak right
There
to
you
the
go.
end.
Sorry,
It's
that's-
very directional. Yeah, Thank you. Pull it right, yeah. And speak right into the end of it, yeah.
Everyone else has been a little taller than me, so I'll have to apologize. I'm Darcy Pizer. I'm from Durbin Law Office in Portsmouth. The law office is located at 144 Washington Street. And I'm speaking on behalf of Kathleen Thompson from 56 Ridges Court. Mrs. Thompson, along with many of the other residents of Ridges Court, object to the proposed construction on the basis that it fails most, if not all, of the criteria for the reasons outlined in the letter, which I previously submitted on July 19th. Mrs. Thompson has lived at this property since 1976. It's been in her husband's family since 1930. The property holds immense sentimental value for Mrs. Thompson. It's where she raised her children, and it's where she currently has expansive views of Little Harbor. And so before I get to the diminution in value factor, I'd like to first speak to the unnecessary hardship factor. So as a first basis for her objection to the proposal, there is clearly no unnecessary hardship proven by the FOI's application. The property is bounded by water, but this does not distinguish it from the surrounding properties, which are similarly situated. In the present instance, there is a fair and substantial relationship between the purpose of the front yard setback restriction and its application to the property. The front yard setback restriction is intended to protect the light, air, and space of the abutting properties. Building a significantly sized structure in the location proposed will have a hugely detrimental effect on the Thompsons' property in this respect. Moreover, it's important to highlight that the relief to build a garage on the property was already granted in 2002. That space was ultimately converted to living space and is not now utilized as a garage, which is thus manufacturing the stated need now to create a similar structure. The Foy's property already boasts 2 driveways, 1 garage, the additional converted garage space, and ample room to enjoy their views of Little Harbor, including a wraparound porch on the south-facing side. So in the present instance, the Foys could comply with the ordinance, but instead they have chosen a structure that is more aesthetically appealing to them at the expense of Mrs. Thompson and the abutters on Ridges Court. While we're not advocating for it, the reality is that the proposed structure could be moved back so that it creates less of an obstruction. I think it's worth reiterating that 100% of the proposed structure lies within the wetland setback. And so the structure could be situated so that it complies with the 30-foot setback ordinance with an equal effect to the buffer, without unnecessary hardship to the Foys. And so now turning to the factor of the diminution in value, I think experts may disagree as to the substantialness of the diminution in value which the structure will cause to Ms. Thompson's property, but it can't be denied that the view will not be negatively affected by the proposed construction. And Mr. Stith, if you could please go to Exhibit 2 of the supplemental materials which were submitted yesterday, which shows the sight lines from Mrs. Thompson's property, excuse me.
Sure. This one, let's see.
I think it's one below.
This one.
That one, yes, thank you very much. So obviously, supplemental materials to the FOIS application were submitted At the end of the day yesterday, which included contrary opinions to that of Ms. Goodwin, a realtor with Keller Williams, who could not be present tonight, with regard to the diminution in value factor, Ms. Goodwin's opinion was submitted as part of our initial objection, and I should have said before that I'd like to incorporate all of the material submitted in July with hereby reference. So the FOI's initial application didn't discuss in depth the diminution in value factor with regard to the surrounding properties. I believe that there was 4 sentences on it. And so now they have had a month to compile evidence that their planned addition will not reduce the value of surrounding properties. And unsurprisingly, they now produce such evidence, which we have not had an opportunity to review in depth. But I'd like to say that the submitted opinions of the Stanhope Group and Ms. Valeri and Ms. Goodwin's, it's worth repeating that they are competing expert opinions regarding the reduction in value to Ms. Thompson's property caused by the proposed construction. However, the abutter view shed markup submitted by the FOIs with the FOI supplemental materials yesterday shows the existing and proposed view lines from Mrs. Thompson's property. And as Mr. Stanhope's report states, not all views are created equal. And it's hard to believe that a reduction in sightlines as significant as what is shown here would have no detrimental effect on surrounding property values, chiefly Mrs. Thompson's. So for the foregoing reasons, we would respectfully request that you deny the variance relief sought tonight.
Thank you. Are there questions from the board at this point? No. Mr. Lee?
So I'm not sure if you've seen the photograph with what I assume is the addition drawn in red.
Yes,
Seen that?
I have.
Okay, so that purports, I guess, a view from your client's property.
Correct.
If you walk, and so that's the view from there. If you walk, just for example, 10 feet down the street, would you be looking at a different view then? Down the street, toward the end of the street, it's a dead-end street.
Yes, yeah, you would be seeing more of the view of Little Harbor if you walked 10 feet down the street. I believe that photo was taken probably dead center from the from Mrs. Thompson's front porch.
Okay, thank you.
Okay, thank you.
Anything else? No, apparently not. Okay. Is there anyone else who'd like to speak in opposition? Please come up.
Can I hand this to you all?
Thank you.
So, hello. I am Robin Hackett from Ridges Court, and I'm here to speak against the granting of the variances requested by the FOIs. That document that's going around is the letter that I'm about to read with wet signatures. I originally wrote the letter and collected electronic signatures, and that's the same letter signed, in ink by all the people.
Excuse me, just for clarity, you're at 46 Regis.
I'm at 46 Regis Court.
Thank you.
Right, across the street from the Foy's place and next door to Kathy Thompson. So I'm going to read this letter, co-authored by me and Marta, my neighbor, are on the other side, and then I'm going to make a few points that reflect my evolving understanding of the situation, over the last month. So the letter, which is signed by however many people you see there, reads thusly. We, the undersigned, respectfully request that you deny the application of Melissa and Jeff Foy for variances to allow them to build a 718 square foot garage topped by living space and a deck. We have no feelings toward our new neighbors other than welcoming. The neighborhood of Ridges Court is beautiful and friendly, even the mud. We welcome the Foys to work with us in stewarding the community that we enjoy. But the Foys' proposed addition negatively impacts our enjoyment of our individual properties, including views of the water from some of our porches and from the street for neighbors and passersby, of which there are a great number. Beyond the negative impacts on us, we're aware that setbacks and regulations about lot coverage are in place for reasons related to the public good, including aesthetic and ecological impacts. We are in support of such protections. Our neighborhood is on a sensitive waterway. It's on an estuary, which is a nursery to the ocean and impacted by changes to runoff. It supports eelgrass, which is protected across the region. Regulations based on best practices for the environment and the social welfare of a community exist for reasons, and they're worth adhering to. About hardships, the lot at 67 Ridges, the lot at 67 Ridges Court occasions, we note that our neighbors asked for variances to build a garage, which they already have. Indeed, the former owners built a garage, which they never used as such, but rather finished as living space. Is it a greater hardship to return a garage to garage use than to construct a new building? Our new neighbors also asked for a variance to add a porch to the top of the new garage building, yet they have a porch which offers a broad view of the water. Is it a hardship of the land not to have 2 porches? Our neighbors request a variance to add living space to the top of the garage as well. However, their property is not judged able to support 2 buildings or an extended building positioned in the way they describe, and simultaneously maintain environmentally protective setbacks. Is it a hardship not to be able to add dwelling space into setbacks? Perhaps it is. But were we all to add dwelling space into setbacks, we would further overcrowd and aesthetically diminish an already densely populated neighborhood and damage protected waterways. Moreover, we wonder if the hardship associated with building a conforming addition is that it would block the Foy's view. Our variance is in order when their impact is to protect the view of a property owner at the expense of views enjoyed by conforming properties. Thank you. And this letter, which I co-authored with Marta, was signed by all the people that you signed there. Since I wrote that letter, my understanding has evolved a little bit. They have a few extra points regarding property values in particular. I note the logic of the argument that the proposed addition will increase rather than decrease my property values for sales purposes. Sales prices are based on comps, as we all know, which go up as houses in the neighborhood build additions or get larger, right? But this logic considers sales values at the expense of use value. I do not want to sell my house. I want to live in it and have my family continue to enjoy it. And the variances as they're written impinge on my ability to do that. The increase in property values alone impinges on my ability to continue to enjoy my property. My property values go up, my taxes go up. Portsmouth becomes increasingly a place where teachers and nurses and firemen can't afford to live, and that is not in the best interests of the public. Also, I note that people are talking about 2 properties where their view is impacted, mine and Kathy Thompson's. That's not accurate. There are actually 4 properties whose views from their porches, and in my case, the bathroom and a front room and the bedroom, are substantially diminished, if not completely closed off. There are four properties. My family's, Kathy Thompson's family, Martin Warren's family, and the Borges and Perrin family as well. There's 4 houses on Ridges Court that have views of the water that will be partially or entirely gone as a result of this addition. Finally, about the question of hardship, I would like to note a difference between disappointment and hardship. It may be disappointing not to be able to build an addition how and where you want, but not every piece of land can support every placement and every kind of addition. This is a matter of fact. It's also a product of ordinances and rules that we agree collectively are worth maintaining. That's all I have.
Thank you very much. Questions from the board? No? Thank you very much.
Mm-hmm. Oh, so I didn't say that all the 4 properties that will be impacted by this are owned by signatures of the letter that you have. So 100% of the people who will be impacted are opposed to this ordinance.
Thank you. Are there other speakers who wish to speak in opposition, please? Yes, please come up.
Good evening. My name is Mark Hepp. I live at 28 Ridges Court, catty corner up the street from the 67 Ridges Court, and I'd like to address a few issues. One, I just want to talk in general about mud. I've lived in Tucker's Cove on waterfront property. We've owned 393 Newcastle Avenue. I own 390 Newcastle Avenue. I own 28 Ridges Court. When the tide goes out around here and the mud is there, the birds come in, nature comes in. It's a fascinating, natural place. So it's not just a matter of a water view. Also, for almost 4 months out of the year, the sun rises over there. It's not just water view, it's the morning sunrise and the low horizon in the winter with all the reds. It's beautiful. This particular request for a variance puts a 30-foot high, 3-story building smack down in the middle of the setback. And why? They can find a creative way to build their addition without encroaching on the setback. When you look at that picture of the existing house, the prior owners in 2002 very respectfully kept their addition angled off of the tidal setback and the main addition off of any other dimensional setback. Certainly a creative architect could find a way, with all the land that they have, to build this without encroaching on the setback. I have one handout for you.
I'll pass them down. Give me all.
Actually, it wasn't until,
Just let's pass these off so we can follow you on,
okay.
with on the sheet. There we go.
This is just a markup of the drawing that was submitted late yesterday, which I only really saw today, which is the kind of view shed from 46 Ridges Court. What's interesting in all the drawings have been submitted by the applicant, and why we're only talking about a dimensional setback of the front, that setback line is missing off all of the drawings. You would think that would be a highlight, that you should at least see what that 30-foot setback looks like, and that's shown there in red. If, in fact, they complied with the setback requirements, you can see the view shed from 46 Ridges Court would almost not change. It's only changing significantly because they're pulling this building very close to the road. We don't want Ridges Court to look like Hotel Row down in the downtown Portsmouth with a 30-foot high building so close to the roadway. And as far as all the discussion regarding why didn't someone buy a view easement, if you knew, and we do know, that all of that land is in the 100-foot tidal buffer, plus you have the protection of a dimensional setback, you wouldn't think you would need that. Who would come and build such a large structure and block everyone's view by not complying with the rules? So I'm simply asking that the board deny this request and have them meet the dimensional setbacks. Thank you.
Thank you. Any questions from the board at this point? Apparently not. Thank you. Is there anyone else wishing to speak in opposition to this proposal? Anybody else in opposition? Come up if you want to, please.
see, how do I adjust this?
Yes, pull that down, yes. Yes, thank you.
Can you hear me?
Yes.
Okay, good evening to the Board of Adjustment members. I am Kathleen Y. Thompson, and I reside at 56 Ridges Court, located in Portsmouth, New Hampshire, and I have owned this property for the past 45 years. My home at 56 Ridges Court is located directly across from the 67 Ridges Court, the Foy's residents who are requesting a variance. I was first made aware of the request for the variance in person by Mr. Foy on July 4th, 2022. My property has been in the Thompson family for nearly 100 years and in my name and family for the past 45 years. This variance will, without a doubt, adversely affect my property value and grand water views of Salter Creek and the back channel. Other homeowners on Ridges Court will also be directly affected by this variance, my home considerably more than that of any of my neighbors. The variance rules for variance are not met and will certainly cause a hardship and significant change to property values and quality of the life to those affected. The board must see long-term effects when granting variances and that will obscure or eliminate water views and landscapes in Portsmouth. Once the extensive water view on Ridges Court is gone for the present enjoyment of our local neighborhood, it will be gone forever and ever, and also for the future generations. Again, I, Kathleen Y. Thompson of 56 Ridges Court, New Hampshire, believe that variance rules have not been met, and the Board of Adjustment will deny the variance after closely examining the affected homeowners' real concern, my attorney filed documents, and those presented here this evening. Thank you for your consideration.
Thank you. Any questions from the board at this? No? Thank you very much. Other speakers in opposition, please. Anyone else?
Good evening. My name is Marta Rubinik. I live at 40 Ridges Court with my husband, Warren Wilson. This is just very brief and from the heart. We're very grateful to live in Portsmouth. The serenity of this town draws many to want to live here as well. The particular character and camaraderie of Ridges Court are worth preserving. Those of us most directly affected by the proposed building plan will detract from our beautiful views and quality of life. And so we strongly oppose the granting of these variances for the Foys. Others, though less impacted, are also sympathetic to this situation. In this world of increasing troubles and challenges, we sincerely hope that this little corner will be protected. Thank you.
Thank you. Anybody else? Any questions? No? Other speakers, please. Yes, please come up.
Good evening. I'm Nancy Andrews. I live at 161 Sagamore Avenue in Portsmouth. And I've spent a good number of hours on Ridges Court visiting with my friend Kathy Thompson. I just want to point out that as a member of the general public, I feel that I'm really harmed when you start taking a South End property that is placed in a very quaint and beautiful community, and you start adding huge pieces of buildings set very close to streets, so that soon a beautiful little street like Ridges Court looks like the hotel area downtown. I've lived in Portsmouth for over 50 years myself, and so many of my friends who've lived here a long time talk about how sad it is that the city has changed its character and the way it looks. And I think this is an example of the way things start to change and the way things start to harm the city. I just urge you to think carefully about the character of the beautiful little neighborhood that Ridges Court is. Even on Sagamore Avenue, we are friendly neighbors and we protect each other, and we live across from the cemetery and it's a busy street. But the neighbors really care about each other, and we take care of each other. And I see that on Ridges Court, and it just breaks my heart to think that the character of the South End might also start changing and will start looking like the Hotel Row. I do urge you to look at why there are ordinances and why they're put on the books. And I don't see a reason that things have to be changed here to build a huge garage. I also love the mudflats. That's when the herons come out. So that view is very beautiful. Thank you for listening to me.
Thank you. Questions? No, apparently not. Other speaker, excuse me. Other speakers in opposition, please. Please come forward. Anybody? Yes? Yes.
I'm Warren Wilson. I live on 40 Ridges Court. And the previous architect for McLeod's did a masterful job in nestling that house in its surrounding area. To put in this addition will be really out of scale. It'll be out of proportion. And I can't help but feel that the Foys will step back one day and take a look at it and realize that it's just too big for the area. Mr. Hepp pointed out that there is creative ways to get what they want or they would like, and that should be considered. But the proportion is going to be all off if that happens, if they build that addition. Thank you.
Thank you. Other speakers, please? Anybody else? In opposition?
Good evening. My name is Mike Rainboth. I live at the end of Ridges Court that abuts Newcastle Avenue. I haven't met the Foys yet. I'm sorry you have to go through this. I'm sure it's not a pleasant experience. Whenever you move into a new neighborhood, you hope to have a welcoming committee and people enjoying each other. And it's a very emotional decision you have to make. It's not just about legal issues and setbacks and zoning requirements. It's a very difficult decision. I do not envy you in the position you're in. I just want to add my thoughts to this subject. I've lived in this house for 17 years. My wife and I were actually married on your property, underneath the tree that sits on your land. I've sat many nights on Kathy Thompson's deck talking to her and looking out over the beautiful view and looking under the tree where my wife and I were married 17 years ago. This addition will block that view. What does that mean? Who cares about that, right? Well, in the words of Daniel Webster, remember, it's a small college, but there are some of us who love it. And this is a small view, but there are some of us who love it. And I would ask you to take that into account when you make your decision. Thank you.
Thank you. Any questions from the board? No? Any other speakers, please? Excuse me. Yes, please come up.
I'm Dylan Pala Hackett. I live in 46 Ridges Court with my mom. So I lived there my whole life, and it's pretty sucks kind of having to be
Could you speak up a little bit, please, so we can hear you better?
I lived in 46 Ridges Court my whole life. I'm 17. It kind of sucks having to come up here and defend it from, you know, having a building block it, the one view that we have. I know that the lady over there said it's not very beautiful, but she doesn't live there, and that's what we have. So it's nice to have.
Thank you. Any last call for speakers in opposition? Anybody? Last call, last call, last call, okay. 2, for, or against. Anyone wishing to speak to, for, or against, whether or not you've spoken before. Come up, please. Yep, thank you.
I just wanted to say a few things. I know that, and we learned very quickly how emotional this was for a lot of the neighbors, and I can appreciate that. My wife and I emailed everyone and asked that if they'd like to come speak to us about it and understand it, we'd be happy to do that. And we had an opportunity to speak to some of the folks that are here tonight, as well as others who are not here tonight. There's a couple things that were said that are inaccurate, and I wanted to just point them out. When we bought the property, there was a single-car garage on the property that had been converted, I guess I was told initially to an in-law apartment and then eventually to an office. And it was stated that we could just return that to a garage as it was intended to be. That's exactly what we've done. It is a garage again. All of that has been removed, and it's a garage. It's a single-car garage. There was also said that the addition, although I'm not disagreeing that it impacts a portion of several different homes' views, it does not 100% block anyone's view. That's not mathematically possible from an angle standpoint as you move up the street. A lot of the view falls down Ridges Court, as you can see there, to the water. So again, I know that folks are sensitive about this and feel as though something's being taken away from them, and they're thinking of it as its entirety, and that's not accurate. You know, we started out with a plan that was even larger than this. That was proposed by the architect. We didn't want that. We scaled it down. We got it to fit entirely on the existing asphalt area, the impervious surface, and that we were intended to actually remove some impervious surface. But to have the garage that was an office or whatnot before, and to have a full-size garage bay and then a shorter one, which you can see from the plans, is what we felt would fit best and provide for what we are hoping to use at the house. Again, we're not looking to make this difficult for anyone, and we respect people's opinions, and that's why we've come up with what we have. In terms of the setback piece, and I think what was dropped off by Mark Hepp, and he had given that to us when we met at our home with him and his wife Ellen, you can tell that it doesn't work. I mean, you know, you're barely touching the existing structure at 30 feet back. It doesn't work. It doesn't work for a flow, but it also just doesn't even really attach enough to even make it. One of the things too about the setback is that the setback is it's not on the side of the road. It's actually onto my lawn, right? So that's where the counting of the setback starts. You can see that dotted line there. It's not on the street or at the edge of the street. It's actually onto the lawn. And so we worked with that as best we could. There was one other point I wanted to make, and I'm trying to remember what it was. They talked about Hotel Row and properties being on the street and stuff. Again, this addition is back from the current house. It's further from the street than any of the four that are impacted, their viewers are impacted. This addition is further back, much further back than their homes are today. Okay? And you know, although the Vandermark's home at 86 Ridges Court, they see this addition. We spoke to them about it. They're not here this evening in opposition to it. They didn't sign the letter. They have a view of this addition as well, and whatever view is impacted for them, it's impacted, and we know that with the addition. So that's all I have. Thank you.
Thank you. Any questions from the board? No? Okay.
I'll be brief, Mr. Chairman. First of all, John Shagnon from Ambit Engineering, who is here and who prepared our plans, has asked me to note for the board that this plan prepared and just handed in by Mr. Hepp is a plan that was prepared by Ambit, and it's owned by Ambit, and correct me if I'm wrong, from an engineering standpoint, it's improper. I don't think Mr. Hepp necessarily knew that, but it's improper for someone to take someone else's plan and just use it without their permission. So he has asked me to ask the board to take note of that and to not, certainly you've seen it, and you get the point that Mr. Hepp is making, but Mr. Shagnon feels that it should not be in evidence because it is a wrong, if you will, I think accidentally wrong amendment to his plan. So be that as it may. Just a couple of points. Attorney Pizer mentioned about the front yard setback and hardship and the purposes of it. And I think I covered that pretty clearly, what the purposes of a front yard setback. What they are not intended to do under zoning, and I have never seen a case that says otherwise, is to protect someone's view past your property. It's to protect air and light coming across your property. No one's is really harmed in any way. Granted, some of their view is now limited because of the building, but they still have views. And again, for the reasons that our experts stated, Peter Stanhope being a 40-year appraiser who has done an analysis of comparable sales in the area, which demonstrates there's no diminution in property value. And I perfectly understand, because I've had it happen to me, somebody building something in front of your home that's between you and what you want to look at, but that is an emotional respect. I'd also like to take a very brief moment to say that, being a practitioner in this, it does sometimes get pretty emotional, and I, for one, from an outsider, have been very impressed with respectfulness of the neighbors, both towards my clients when they've met with them and here tonight. That doesn't always happen. Ms. Hackett mentioned environmental concerns, and I would just again remind not so much the board maybe, but the public, that those kind of concerns are not this board's purview. That's the purview of the planning board. We go through conservation. I mentioned that there was a mention of a use value, and that use value is not a legal issue. It's a diminution in property value. We've demonstrated that that's not going to happen. The handout that Mr. Hepp used, I'm no architect, but I think from what Mr. Foy said, you can't just plop a building onto another building. You have to make it work with what else is the structure that's already there inside. And so they were adding to living room space, creating bedrooms and the like. So I can't say for certain because I'm not an architect, but I think just putting that red box on the back of the house doesn't tell the story that is even possible. Other than that, I've made my arguments. I won't repeat them here, but we think we've met all the requirements for the variance. We understand and respect the concerns of the board and their loss of view, but there's been no demonstration that there's any loss of value. Thank you.
Thank you. All right. Last call, last call. 2 for or against, please come up.
Good evening, board. My name is Evan Mullen. I'm here tonight in opposition to the variance being applied. I am a resident of Austin Street, but in this capacity, I suppose I'm speaking as a member of the general public. I'm also a friend of Kathy Thompson's, and I've had the benefit of sitting on her porch, having a lovely conversation with her while she picks honeysuckle from her vines and feeds my child animal crackers. I also have the privilege of designing buildings for a profession, and I would just point out that a couple of the canons of the AIA Code of Ethics employ architects to that they have an obligation to the public and they have an obligation to the environment. And so I would challenge the design team of the applicant's addition to consider that and any possible alternatives they could come up with as options that might be less impactful to the surrounding community. Thank you.
Thank you. All right. This last call. Seeing nobody, Mr. Sidis? No, okay. Public hearing is closed. Okay. Board, we've had an opportunity to hear quite a bit of testimony on this particular proposal. Sounds like I sense a lot of thought has gone into the comments we've heard this evening. Does someone want to start the conversation? Ms. Eldridge.
I don't think I can support this variance because I absolutely don't see a hardship. We were told that the reason the variance for the setback is needed because of all the buffer zones. And that is the hardship, that there's so much land that can't be built on. And yet this is built 100% in the buffer zone. So what difference does it make where you put it in the yard? I just don't see how it needs to be there. Architectural problems aside, I cannot see why this needs to have a variance when with the same hardship, it can be anywhere. So that's how I see this.
Thank you. Who's next? Who's next? Mr. Mantle? Do I sense a...
No, I'm just, it's an interesting proposal. I understand the emotional arguments. I understand the view arguments. Frankly, I find it fascinating when one side, as far as the real estate appraisals, says the water view, well, you know, half the time it's only mud. Both real estate experts said that, which I thought was quite interesting because you're putting the master bedroom in a deck to view the mud. You can't have the same argument, pro and against. That's something that doesn't work for me. But to Mrs. Elger's point is that the addition's fully in the wetlands buffer, and I understand how an architect wants to line it up and have nice straight lines and so on and so forth, but if you observe the setback, I don't think we'd be here tonight. I also find it kind of difficult for the Conservation Commission to grant this. But if they did, you know, the difference of another 10 feet, another 15 feet, I can't see where it would make a difference because you're fully in the wetlands buffer. That's where I'm at right now.
Okay, thank you.
Thank you.
Who's next? Mr. Lee?
Well, I'd make a comment about views. I was thinking back when I was in the Air Force in the late 1960s and stationed in Florida, in Destin, which some of you may be familiar with. You could drive along the beach and there would be miles and miles of snow white sand dunes and a view of the tides in the Gulf of Mexico. If you go back to that same area now and drive along the beach, there's 10-story condominiums along there. However, that is what the learned appraiser was talking about territorial views. In the 1960s, that was a territorial view. In 2022, the condominiums are the territorial view, and that's what you're looking at. So that would be my comment about views.
Ms. Eldridge. Ms. Margison, excuse me.
So I want to thank both the applicant and the neighbors for speaking so respectfully and also knowledgeably. And I just want to note for the record that this board does not have any jurisdiction over the views. The applicant's request was for front yard setback. That is what we're tasked with deciding today. And also, you know, I share absolutely everybody's concern about the loss of building within this wetland buffer. It's clearly delineated in the ordinance under the environmental protection standards. However, again, that is not something that this board can take into consideration. I hope someday the city council changes the zoning ordinance, but right now that is the zoning ordinance that we have in place. So those are two things to keep in mind. But that said, one of the reasons I asked Attorney Phoenix where the tidal buffer zone was, and now I can see it clearly on the plan is that I agree with Ms. Eldridge. You know, if the tidal buffer zone were pushing this project closer to the main building, I would have a different view of it. But where everything is built, anything that has to be built on this property has to be built within the tidal buffer zone. So I can't really say that that is a hardship. And that is something that I've kind of changed my mind at, listening to the conversations here tonight. So those are my thoughts. Thank you.
Thank you. Thank you. Anybody else have anything at this point? Excuse me. No? Anybody inclined to make a motion? Are you warming up to that, Mr. Manley?
No, I'm not warming up for that.
Okay, okay, fair enough.
This is a hard application. It is.
Very hard
Very hard application.
Yes. Yes, that's clear. Anybody else, anybody down this side have a?
I'll try it.
Just try? Thank you. Thank you, Ms. Eldridge.
You can offer advice as we go. I'm going to move that this application not be approved tonight. And as I said before, for me, the main reason.
Let's see if we can get a
Oh, right,
message.
no,
Yeah,
second.
thank you. Do we have a second, somebody to second that so we can move along?
Second.
Mr. Mantle, thank you. Ms. Eldridge.
So the first three criteria have to do with public interest and does it meet, substantial justice. And I do agree that this is really written not for the neighbors, but for the general public. And in that case, I have to say that I think it isn't really contrary to the public interest. And it does observe the spirit of the ordinance. And yes, you would benefit more than, no, I don't think you would benefit more than what the neighbors would lose. And I have no idea about the property values. Maybe it doesn't diminish them. But they're going up so high anyway that this isn't probably going to stop that in Portsmouth. But the hardship just isn't there. When you're saying we need to avoid the buffer zone, and you're not avoiding it, you're just on the buffer zone, but within a setback, when you could be on the buffer zone almost any place else with perhaps new architectural plans. And that's why I cannot vote in favor of this.
Okay, thank you.
I concur with what Ms. Eldridge said.
All right.
Because the property is problematic as far as the wetland buffer, you knew the hardship going in. And to have us grant something that's fully in that when you could move it back and eliminate all these things, all the emotional responses, that, yeah, I cannot support it. I wish I could. It's a beautiful house. It's a beautiful area. I remember when Kevin actually redid it. But I will support the motion for my second.
Thank you. Anybody else have any? I will just add, I have wrestled with the hardship aspect of it also, particularly where it says, conditions of the property that distinguish it from other properties in the area. Well, there are other properties in the area similarly situated, that's for sure. And I agree with the analysis with respect to the excuse me, the wetlands setbacks. It's in the setback already. So that's not a unique feature that this board has to look at through a glass lens, or however you want to put it, an odd lens, but because it's there already. So that's not something new. So having said all that, not very well. We have a motion on the floor, and the motion is to deny the proposal. And I just would, let me just add another general comment, that I as well see opportunities to redesign this to deal with some of the concerns that have been expressed this evening, so, for what that's worth. So, having said all that, if nobody else has anything further to say, I would propose we move to a vote, and the vote will be on the motion, which is to deny the application. Mr. Mantle?
Yes.
And for the record, Mr. McDonald is recused. Mr. Lee?
Reluctant, yes.
Yes, all right. Ms. Margison?
Yes.
Ms. Eldridge? Mr.
Yes.
Mr. Rossi is Mr. Rossi is absent, and I vote yes as well. So that's the action on that one. So the.
You want me to take your papers? I've been going back and forth all the week, and all of a sudden it's like,
You could have to ring.
Oh, shoot. Wow. Do we earn our money on that one, Peter?
they can do this.
Do we earn our money on that one?
If the conservation committee will let them, that's one less variance than, you know. But that's gonna be true. But to say that, oh, look, we can't put it there because it doesn't connect.
I made about 3 visits down there.
I know the previous owners, they talked about the McLeods.
That was fun. It was fun. It was amazing. I actually.
Lost all the fun.
I started to change my mind. Well, actually, I was ready to
They were all nice.
I guess, I don't know if it's a thank you, but it made sense to you, and that makes me proud.
Well, I just.
Could you move your conversations out to the lobby, please, folks?
Not particularly clear, but the important thing is that it didn't meet all the criteria.
I still feel bad though, because I was.
Oh, I don't actually. They have choices.
Turned it up to 11.
The next item on the agenda this evening is with respect to the property at 225 Banfield Road, and there is a request to postpone that. And
Mr. Chairman,
someone have a motion?
make a motion to postpone?
Thank you. Second?
Second.
Mr. Lee, second. Thank you. The motion is to postpone it until next month?
Yes.
Correct.
Thank you. Those in favor, please say aye.
Aye.
Any opposed? No? No surprise there? Okay.
Can somebody close the door?
Okay. All right. That takes us to the next item on the agenda, and if I could find my agenda, I'd be all set. It's got to be under here. There it is. Thank you. I'm going to make a bold prediction. This one will be a lot easier.
Aren't you silly?
That's, yeah. Silly me is right. This is, we are now in new business. The first item was the request to postpone, which we have dealt with. Item B reads as follows. The request of Lonza Biologics owner for property located at 101 International Drive, whereas relief is needed for the addition of a 372 square foot wall sign, which will result in 487.5 square feet of total sign area, which requires the following. A variance from section 306.01 sub D to allow 887.5 square feet of total sign area, where 200 square feet is the maximum allowed per lot. Said property is located on Assessor Map 305 as Lot 6 and is located in the Airport Business District, Commercial ABC District. Who speaks in favor, please? Who speaks in favor? Anybody? Yeah, thank you.
Hi, good evening. My name is Brandon Courier. I'm from Barlow Signs, here representing Lonza.
Yes. Come on up and just.
Can you guys
introduce
all hear me?
yourself. Hold on, Brandon. We do have the sign rep on the Zoom call.
Oh, okay.
And then
Okay, thank you.
I'm Katie Harnedy. I'm from Barlow Signs as well, but Brandon will be doing the presentation.
Okay, thank you. Yep.
Thank you.
You're going to stay right there for questions?
Oh, okay.
Thank you. Might as well.
Why not?
Go ahead. Go ahead. Go ahead.
All right, so good evening. My name is Brandon Courier. I'm from Barlow Signs, here representing Lonza. Katie just introduced herself, and we also have a representative, Ross, attending from Lonza. I appreciate you allowing us to present this case over Zoom this evening. So as mentioned, we're here this evening seeking variance approval for a wall sign that is 487.5 square feet, where 200 is allowed in the Airport Business Commercial District of Pease. As you know, this is an extremely unique location due to its sheer size and location. As construction of this portion of the building is completed, there was an opportunity to have the sign placed in not only a visually appealing position, but also in a spot that allows for identification to be seen by many more motorists daily. On paper and writing, the proposed total square footage may sound large, but it is approximately 4.5% of the overall facade on the backside of that building. Having this identification will attract new customers and aid current customers in locating the building. When approaching this district, there's a lot of buildings that seem identical to people that are not familiar with this area. Having seen the name on the building while approaching from the highway helps aid the everyday motorist to their location as it familiarizes their brain with that location. In the past few months, we've been working and we have appeared in front of the PDA. We have their support with the proposed wall sign in front of you this evening, with the one condition that we remove the existing wall sign off of that same elevation, which we agreed to. The existing sign is located on the lower section of that building, and as trees and whatnot continue to grow, that sign will then not be visible. Most of those trees that will be growing up will be on a different property. So having the sign will not be contrary to the public interests, as it will not be a distraction or cause harm to surrounding properties or pedestrians, as it is within character of the building. Since this sign is located on such a unique building, it is consistent with the spirit of the ordinance, as we are keeping a sign within scale and function of the building of this size. A smaller sign would look distasteful and out of place on a building of this scale. Substantial justice here has been done, as this property is extremely unique in the part of this community. As it is a commercial district, the surrounding neighbors will not be affected, nor will it diminish the value of their properties. Enforcement of the provisions would cause a direct hardship on Lonza due to their unique location, deep setback from the road where the majority of the new and current customers will be identifying them from. Thank you, and please let me know if there's anything any questions that we can answer. Again, I have Katie and Ross there from Lonza. Thank you.
Thank you. Okay, any questions from the board? Do I understand it correctly? Is this an additional sign, or is this going to replace the sign that's there?
This is going to be replacing a sign that's there.
Okay.
It's just in a different location. So if you scroll down, you keep scrolling down. Keep going, that's an old sign. Keep going down. That's the new one. It should be a couple more. You'll see the existing drawing. Should be a site map. There we go.
You passed it. There it
One
is.
more page. Here we go. So the top left is where the new set of channel letters will be, and where he has the mouse right now is the set that will be removed.
Okay, and how will that be lighted?
It'll be internal illumination.
Okay. Any question, anything else from the board? No, apparently not. Okay. Thank you very much. Anybody else present who wish to speak in favor? Anybody present wish to speak in opposition? Anybody present too for or against? Any speakers at all? Apparently none. Okay, we'll close the public hearing. Thank you.
Thank you.
Is there a motion from the board? This is the form of a recommendation to the PDA.
Chair,
And again, using their criteria.
Yes, yes. Mr. Lee, yes?
I'd move we approve this application.
Thank you. Is there a second? Who's the, Ms. Eldridge, thank you. Mr. Lee, your motion?
So, Peter, did you say we use their criteria to?
Right, that's in the
is
staff
where?
report, to recommend approval, yeah.
Okay, I guess I'm not finding that.
Page 54.
Before.
In other words, we can't approve it on our own.
Did you say?
I second it, yes.
We back up to page 54.
Their criteria is in 6, 7.
Oh, it is?
So where the certified motion is?
Their criteria is
That's
on
my page
67.
54.
Their criteria is on.
I got it.
Okay. All right. So, apparently the Pease Development Authority finds that there is no adverse or effect or diminution in value of the surrounding properties. Granting the variance would be a benefit to the public interest. Denial of the variance would result in an unnecessary hardship to the person seeking it. Granting the variance would be substantial justice. The proposed use would not be contrary to the spirit of the zoning rule. And I'll just add that, you know, the sign is a pretty big sign. It's 48 feet long and 8 feet tall. But I believe that the scale of the building justifies a sign of this magnitude. So for those reasons, I would move that we approve this variance.
Thank you. Thank you. Thank you. Is it Mr. Mantle?
Mr. Lee said, I mean, it's a sign at PDA, and we're just doing a recommendation.
That's right. Yeah.
Considering how much Lonza has done for the PDA, especially in the past 2 years, 4 years with the vaccine, I see no reason not to make the sign bigger.
Well said. Okay, sounds like we're all ready to take a vote. The motion is to approve as presented.
Yeah, recommend approval.
Recommend approval as presented, yeah. Mr. Mantle?
Yes.
Mr. McDonald? Yes. Mr. Lee?
Yes.
Ms. Margison?
Yes.
And Ms. Eldridge?
Yes.
Yes. And I vote yes as well. Okay. Passed.
Thank you very much, everybody, for your time this evening.
You're welcome.
Really appreciate
Thank you.
It all should be so easy.
Yeah.
Okay. Okay, what time is it? Oh, 9:15. We got another one in us before 9 o'clock break? Yes?
We can.
Sure.
I think so.
Easy.
Okay, good. All right. That brings us to item C under new business. It's the request of Richard P. Fusini, for a property located at 201 Kearsarge Way, whereas relief is needed to subdivide one lot into 3 lots, which require the following. 1, a variance from section 10.521 to allow 82.5 square feet of street frontage, running street frontage, where 100 feet is required for proposed lot 3. Said property is located on Assessor Map 218 as Lot 5 and lies within the Single Residence B SRB district. Who speaks in favor of this proposal, please?
Good evening, Mr. Chair and members of the board. I'm Chris Mulligan from Boson and Associates in Portsmouth on behalf of Dick Fusini, who's behind me here, owner of the property. I also have John Shagnon, who's the project engineer on this. This is a project that some of you may recall seeing in certain iterations in the past. In fact, my late colleague, attorney Bernie Pielich, got substantially the same a relief from this board a couple of years ago. Basically, the plan is to get approval to subdivide an existing lot at 201 Kearsarge into 3 lots, 2 of which are fully dimensionally conforming, 1 of which requires less than 20 feet of frontage relief. That's essentially the same variance that Bernie got in the fall of 2019. What happened is that as the project progressed through the planning department or the planning board and technical advisory committee, what happened is there was an amount of mature trees on the property that would have had to have been sacrificed to accommodate the designed drainage improvements that would accommodate the 3-lot subdivision. So that was fully approved, got through the planning board. The planning board approval is part of your packet. However, when Mr. Fusini understood the impact and the import of the loss of that many mature trees on the property, which are extremely important to him, he put the brakes on it. And we went through a number of different internal design discussions, for lack of a better word, to see if there was anything we could do. We looked at perhaps coming back and requesting front yard setback relief to push the building envelopes away from the mature stand of trees in the rear. We looked at possibly condominiumizing the property in different projects. However, what we came to light on is a plan that's very similar to the one that was already approved, but Mr. Shagnon and his team have come up with a design that will allow us to preserve substantially preserve the trees in the rear of the property. You can see on the proposed site plan, the proposal is to dedicate a portion of the rear of these properties as conservation easements. Actually, the rear of the property abuts an NRP zone, so there's very little opportunity for additional development after this subdivision is approved, should we get the relief we're requesting tonight. Again, the two outer lots would be fully compliant with zoning. It's just the lot in the middle that has less than 83 feet of frontage, where 100 feet is required. So that's all the relief we need. Otherwise, it's a 1,500 square foot lot. There's a building envelope that is sufficient to comply with all the necessary setbacks. So that's the project and the relief that we're requesting. Just to get through the 5 criteria necessary to grant a variance. Granting the variance we're requesting tonight would not be contrary to the public interest, nor would it be contrary to the spirit and intent of the ordinance. Here you have to look at the characteristics of the neighborhood and determine whether or not they would be substantially altered by what's being proposed. What we're proposing is single-family residential lots in the single-family residential zone. So the characteristics of the neighborhood as a residential neighborhood would not be altered in any material way. Health, safety, and welfare of the public would not be compromised. Again, all the lots meet all the dimensional requirements except for the middle lot, which is less than 20 feet short of the required frontage. Substantial justice would be done by granting the requested variance. Here, the loss to the applicant clearly outweighs any gain to the public if strict conformance with the frontage requirement is required. We, again, are looking at very minimal relief. The purpose of having frontage is to make sure that you have lots that are adequately spaced and have adequate access and are not overcrowded. There's nothing about this proposal that suggests any of those concerns are present. Values of surrounding properties will not be diminished. As a result of this project, you'll get new construction of new homes, which would increase values in the neighborhood. Would also add additional housing to the city's housing stock. It would add would add to the city's tax base. So values of surrounding properties would not be negatively affected by what's being proposed here. Again, very minimal frontage relief. And finally, as far as unnecessary hardship, there are special conditions of this property that distinguish it from others in the neighborhood. It's a very large lot for this area. The tax map that was submitted with materials, I think, demonstrates that pretty clearly. This is a very significant large lot and is much larger than most of the lots surrounding it. It's bounded by a paper street in the rear, that's Oak Street. Abutting that is the NRP zone, so again, there's limited development after this project goes forward. So this is not going to be a situation where there's going to be substantial overcrowding or any concerns like that. It has sufficient frontage for the 2 lots, which would be fully conforming, and the relief we're requesting is really very minor, and especially compared to many of the lots that are in the immediate vicinity that have less than 100 feet of continuous road frontage. So there's no fair and substantial relationship between the purpose of the frontage requirement and its application to this particular property. The use is a reasonable one. It's a residential use in a residential zone. So based on all of that, I believe this clearly meets all the criteria as this board found a couple of years ago, and should be approved again at this time.
Thank you. Any questions at this point? No, apparently not. Thank you.
Thank you.
Anyone else present who'd like to speak in favor? Anyone else in favor? Anyone else in favor? Anyone else in opposition? Any speakers in opposition? Mr. Stith, do we have anybody?
We have one person, but they have not raised their hand.
Okay. And last call, 2 for or against. Any speakers, 2 for or against? Apparently not. Okay. Public hearing's closed. What's your pleasure on this one, Bo? And I do remember this one. Yeah.
I do as well.
You remember it also?
I do. I think Mr. Mulligan was sitting up here with us at that time, too.
I'm sure I recused myself.
Okay. I'm sure you did.
Does anyone have a conversation starter or a motion, maybe?
Well, I'd be willing to move that, once again, we approve this variance as presented and advertised.
Thank you. Second on that motion. Mr. Mantle?
Second.
Thank you. Mr. Lee, your motion.
All right. Well, again, as we've observed, this variance is not contrary to the public interest, and the spirit of the ordinance is observed. This doesn't conflict with any explicit or other implicit purpose of the ordinance, and doesn't alter the essential character of the neighborhood, injure the public health, or anything like that. Substantial justice is done because the benefit to the applicant is not outweighed by any harm to the general public. I see that, in my opinion, the values of surrounding properties will not be diminished. Quite to the contrary, I think new construction in that area would enhance everyone's property value. And as far as the hardship, I would refer back to the Simplex Technologies versus the town of Newington, where the Supreme Court sort of redefined the definition of a hardship. And they said a hardship exists when special conditions of the land render the use for which the variance is sought to be reasonable. And in my opinion, this is a very reasonable request and a very reasonable use of the land. So for those reasons, I would move that we grant this ordinance, this application as presented and advertised.
Thank you. Mr. Mantle.
I agree with everything except the case he cited for the hardship. It's ironic that the Lot 3 needs the variance, correct?
Yes.
Okay, and that's the biggest lot. What he said. Thank you.
Thank you. Anything further before we take a vote? No? Okay, the motion is... Ms. Eldridge.
I would just say that it was very admirable that you came back to us to save the trees, and you ran the risk of going to the ZBA again, so thank you.
Ms. Margison.
So I did struggle, because I overthink things, I did struggle whether or not to apply the hardship to all 3 lots or just one. However, I will support the application.
Okay. All the discussion before was about the odd shape front of the
Yes.
middle lot, wasn't it?
We
Yeah.
talked about this
A
for 4 meetings.
A long time, yes. Yeah.
Some would say too long.
Yeah, exactly. So the motion is to approve as presented. So, Mr. Mantle.
Yes.
Mr. McDonald.
Yes.
Mr. Lee.
Yes.
Ms. Margison.
Yes.
Ms. Eldridge. And I
Yes.
vote yes as well. So you're all set.
Thank you very much.
You're welcome. Okay. It's a few minutes to 9. We have 2 issues. Does anyone, what's the sense of taking a break versus pushing ahead, or what? Anybody?
Whatever the chairman's pleasure is.
I'd say 5 minutes.
Yes.
There you go.
No more than 10.
Right back.
15 at the most.
Welcome back. We're back in session for the final two items of the evening. First of which is item D under new business and reads as follows. The request of Marcio Goldani von Mueller, owner for property located at 303 Faxter Road, whereas relief is needed to replace existing entryway with a two-story addition including front landing and steps, which require the following. 1, a variance from section .521 to allow a 14.5-foot front yard where 30 feet is required. Said property is shown on Assessor Map 152 as Lot 37 and lies within the Single Residence B SRB district. And who speaks in favor of this proposal, please? And please correct my pronunciation if I mangled your name.
Good evening, Chairman, members of the board. My name is Scott Boudreau, licensed land surveyor, Boudreau Land Surveying out of Newmarket, representing the Von Muellens on this project. They are trying to put on, like you said, an addition, two additions. One of them impacts the building setback on the front. I have since been given revised plans, and I revised the site plan yesterday, and I have those here, which makes it a little less drastic.
Okay. Yes, start them down the end, please.
There's a revised site plan and just revised architectural plan.
We'll pass them down. Thank you.
I have a vivid imagination.
How many sheets? Two? Two. Okay, go ahead, please.
Okay, the initial application was requesting a variance for 14.5 feet to the bottom of the front steps. Front setback in this zone, SRB, is listed as 30 feet with the exception of the average front offset for the buildings, 200 feet either side of the lot. That average front setback works out to be, just using the enclosed additions, 20.5 feet for the front setback. So we were looking initially for 5.5 feet of relief. With the new revision, you can see the addition is still going to be the same, which the addition is going to be enclosed now, and currently that's a covered entryway. They're just going to convert that to a two-story addition, but it's going to require some sort of landing to get out of that entryway still. So they're requiring or requesting a 4-foot landing area outside of that addition. And instead of the steps coming off the front towards the street, they're going to go off to the side. And that makes that overall request for 18.5 feet instead of the 14.5, where by average it's 20.5. Does that make sense, everybody? So this won't be contrary to the public interest. It's the proposed addition that's covering the same footprint that's already there. It's in a covered entryway. And it's basically due to the sloping topography right there that requires the safe landing area, 4 feet, and then the steps. It was safer for the steps to go off to the right instead of down, where you can see the picture that I took if you want to show that shows the embankment that they have to go down. So that entryway right there is going to be replaced with a 2-story addition, which does meet the building setbacks, but it's the landing area that's going to come out in front of that cuts into that front setback. And then the stairs are going to come off to the side over by where the fence is in that direction. So it won't be contrary to the public interest because it matches the character of the neighborhood. It's a matter of safety with that landing and the steps to come down. It's a 1.5 foot relief that we're looking for. Spirit of the ordinance will be observed. The proposed addition to the existing dwelling meets the dimensional requirements. Again, it's the landing that we're having an issue with and the stairs. Substantial justice will be done. It's going to be an enclosed 2-story structure. It's an entryway where they can keep their shoes when they walk in, coats, and then it's going to provide more area for the upstairs bedroom. And it won't diminish the values of the surrounding properties because it does fit in with the character of all the houses in that neighborhood. And you can see on the plan that many of these houses also have stairs that come back into that same dimensional area, it's the front setback. So it's very similar to some of the other houses in that area. And the provisions of the ordinance would result in unnecessary hardship. The addition meets the dimensional requirements. Again, it's due to the sloping nature of the front yard and the safety of exiting that or egress from that addition, which requires the slight infringement on that setback.
Any questions? No? Apparently not. All right, thank you. Is there anyone present who'd like to speak in favor? Anybody else in favor? Anyone is opposed? Anybody in opposition? Any speakers to, for, or against? Anybody at all? Apparently not. Okay. Public hearing is closed. What's your pleasure, board? Is that a motion? No. Mr. Mantle.
Make a motion to approve as submitted.
Thank you. Is there a second?
I'll second.
Ms. Eldridge, thank you. Mr. Mantle, you.
No, let me go through the granting the variance is not contrary to the public interest. The spirit of the ordinance would still be observed. Substantial justice is done for what they want to do with the property. The values of the surrounding properties would not be diminished. In fact, they'd probably most likely increase. And literal enforcement would be a undue hardship. What we have before us is an established neighborhood that already has now, we're asking for a 1.5 foot variance off the existing, correct?
Correct, using the front yard averaging.
So it will become slightly less non-conforming because it's already non-conforming by 1/3. I don't think that's a big ask here. Thank you.
Okay, thank you. Your second.
I agree and have nothing to add.
Okay.
Could I recommend a stipulation that?
Yes,
since
please.
What was advertised was 14.5 feet, that you stipulate the front setback shall be 18.5 feet per the plan submitted tonight.
For the plan
Right.
submitted tonight, correct.
Thank you.
Thank you.
Absolutely,
Agree?
yes.
Yes, good
Thank you, Peter.
stipulation. Thank you. Okay, anything further? If not, those, we'll call the roll. Mr. Mantle?
Yes.
Mr. McDonald? Mr. Lee?
Yes.
Ms. Margison? And Ms. Eldridge?
Yes.
And I
didn't vote.
I'm sorry.
Yes.
Too fast.
You are too fast. Doesn't take long to vote.
I vote yes as well. Thank you. All right. You're all set. You're welcome.
Slow down, Chairman.
Okay. As a former chairman used to say, our favorite item of the evening, item E, and last.
Oh, a twofer.
Well, no, we got one. Don't.
Twofer.
We got one after this one under other business, but it's not a public hearing. Okay, item E reads as follows: the request of John A. Signorello, owner for property located at 22 Maple Street, whereas relief is needed to subdivide one lot into 2 lots and construct a new dwelling, which requires the following. 1. Variances from section 10.521 to allow a lot area and a lot area per dwelling unit of 8,530 square feet, and 10,400 square feet, where 15,000 square feet is required for each. B, a lot depth of 85 feet, where 100 feet is required. C, 98 feet of continuous street frontage, where 100 feet is required. D, an 18-foot front yard where 30 feet is required. And E, a 19-foot rear yard where 30 feet is required. Said property is located on Assessor Map 237 as Lot 1 and lies within the Single Residence B SRB district. Who speaks in favor of this proposal, please?
Thank you, Mr. Chairman, members of the board. Tim Phoenix from Hopeful Phoenix, Gormley and Roberts, here on behalf of the applicant, Phil Franciosa, who's sitting with me. He's intending to purchase this lot from the owner and develop it. Also with me is Eric Weinrib from Altus Engineering, who has done the plans that you see before you. What we have is 22 Maple is an 18,930 square foot lot in the Single Residence B district. Presently, there is a single home on the lot that's pushed far to the right, as you can see in this diagram. It's partially within the 100-foot wetland buffer, an off-site buffer, and that's the magenta colored line that you can see going through approximately 85% of the home. The lot frontage is just short of 200 feet. You need 100 feet for each lot, so we have left the existing lot with 100 feet and asked for 98 feet. But I would point out that one of the purposes of frontages is for sightline separation from neighbors, etc. And this lot has over 100-foot front line. It's just that this street ends and then turns onto Meadow. As you can see at the bottom there, the lot keeps going. So for the purposes, while we need that variance, the purposes of the requirement for a certain amount of frontage is met. What we're proposing here is a fairly large lot for this area, and I'll get back to that in a minute, cut into two lots. The new parcel would be 10,400 square feet. The remainder is 8,530 square feet. And while those don't meet the requirement for the ordinance lot sizes, they are consistent with many lots in this area, and I'll show you that in a minute. We need lot depth. I'm not sure we need lot depth, but we asked for it, as I always say, in an abundance of caution, because the lot depth isn't changing. It's approximately 85 feet, and of course, if you reduce that by the front and rear setbacks, it leaves a pretty small building envelope, as you can see. For the front yard, the house is at 27.6. The landing is at 21.6, and the steps are at 18. Again, we've asked for all of those, but Eric shows on his plans that the landing and steps are less than 3 feet, and so those shouldn't require variances. I neglected to catch and provide you with the zoning section that says that, and I've had Eric looking for it, but they're in there anyway. The house itself is 28 by 40, which is a pretty standard size. When you're working with homes, you really need to go up and down by even numbered feet for lumber and what have you. So this is 28, and if you have the front setback of the house, meet the building setback, then you're getting at 26, which is pretty narrow for a home. And same with the rear yard. The house itself meets the rear yard setback, but the landing and the steps do not. Again, we don't think we need them because they are less than 3 feet, but they are asked because I didn't think of it at the time and don't have a section to give you that we meet that shows that they don't need a variance. They're inobtrusive, they're low, they shouldn't be a problem. I'd also like to point out, if you look to the right of the magenta line about, I don't know, 2 inches on that plan, you'll see another straight line going kind of through the driveway. That's a sewer line. Originally, we looked at pushing the building over as far as we could to the right, but we can't do that because it interferes with the sewer line. I asked Eric as recently as today, couldn't we push it over some amount? And he pointed out that if you've got a car in the garage, which is under the house, and you back out, say the car is roughly 20 feet long, you have to clear the whole garage before you can turn, and if you do that, you're going to be 5 or 6 feet from that back line. So that's why the house is where it is. for ease of backing out and turning and what have you, you really couldn't push it closer to that sewer line. If you can go, Peter, to the tax maps, which is Exhibit C. So this is, it's hard, a little hard to see here, but hopefully, and by the way, the plan set with the plan sheet with the sewer line on it was more recently provided to you folks. The original one didn't have it. We didn't know where it was. So I presume you got it and it was distributed to you in the last few days. Is that right, Peter?
It's in the packet.
Okay, oh, maybe it did get there in time. So this was the work of my associate, Monica Kaiser. If you can go to the little scale that she did, it's at the bottom left, so there we go. So she's done this, this scale that sort of shows how our lot fits in with the rest of the neighborhood. And let me get to that. So the blue lot at the top there is our lot. The lots that are pinkish are lots in this area that are non-conforming as to frontage and lot area. The lots that are purple are non-conforming as to depth. Now, this is taken from the tax map, not going out and measuring everything. It's kind of eyeballing it. Green is non-conforming lot area and depth, and orange is non-conforming lot depth, area, and frontage. So you can see that there are a number, not all of them, but a number on this tax map. We've also included, is that 236? I think that's 236. We've also included 237, which is the next page, and has, you know, similar, it's a similar document with somewhat similar findings of lot sizes and what have you. So the point of that is that these lots, when they are made smaller, are in keeping in many respects with the size and frontages of many lots on these two tax maps. So we're thinking that this is a very nice location for a smallish lot, not in downtown Portsmouth, but still in Portsmouth proper, that would provide opportunities for perhaps a young family to come in and buy a lot or buy a house that Phil's going to build them at a less expensive price than over on Richards and that area closer to downtown. And the house would be in keeping with size of the lots and the size of homes in the lots out there. So turning to the variance requirements, again, as you just heard me do previously, public interest and spirit of the ordinance tests are considered together by the courts. Will the variances unduly and to a marked degree conflict with the ordinance such they violate ordinance basic zoning objectives? Conflict alone is not enough. You know that. I then go through the requirements of the ordinance, including the use of land, intensity of use, which, as I just pointed out, is reasonable, design for vehicular access and the like. I've just explained that. Impact on lighting, noise, vibration, stormwater, those will all be taken care of. We will have to go to the Conservation Commission and the Planning Board for a conditional use permit for the wetland buffer effect. Preservation and enhancement of the visual environment. We see this as sort of creating a lot that's similar to many of the other lots in the area, and with a modestly sized home on it. I think it's 1,100 square feet footprint. And for those same reasons, this larger lot broken into two is not going to harm natural resources, et cetera. The underlying tests for these two first sections of the variance requirements are: will the variance alter the essential character of the locality? And for the reasons I've explained, we don't think it will, because the lot sizes, frontages, house location, et cetera, are relatively in keeping with much of the neighborhood. Nor will it threaten the public health, safety, or welfare. It'll be a house built to code. The frontage, which is probably one of the major issues, is just a little bit short, and the actual front lot line, as I mentioned, meets the 100-foot setback. The house is only 2 feet. The house itself is only 2 feet outside the front setback line, and there's not much we can do with respect to the wetland buffer because it covers much of the lot. The third test is that granting the variances will not diminish surrounding property values. We think in this case that's a common sense test. I didn't hire a surveyor, a realtor or an appraiser like I did on the last one. due to its nature. Again, a reasonably sized home on a lot that's in keeping with other lots in the area is not going to diminish surrounding property values. The fourth test is hardship. The test is whether there are special conditions that distinguish the property from others in the area. Unlike most of the time I'm here, this is distinguishable because the lot is somewhat larger than many of the area, and by cutting it to these sizes, it's more in keeping with many of the homes in the area. The wetland buffer creates a special condition, as does the 85-foot in depth, which leaves a fairly narrow building envelope, and all of those things combine to create special conditions. I'd also point out, and it's in my papers, that there are other ways to determine hardship. I've cited the Walker versus City of Manchester case, which found that a hardship may be found where similar nonconforming uses exist within the neighborhood and the proposed use will have no adverse effect on the neighborhood. As I've mentioned, there are numerous small lots with insufficient frontage, insufficient size, homes that look closer to the lot lines than the present zoning would permit. So adding one more home when those same circumstances are found in the neighborhood is not going to have an adverse effect on the neighborhood. There's another case that I've cited, Belanger v. City of Nashua, which says a municipality's ordinance is supposed to reflect the current character of the neighborhood. We believe the ordinance does not in this particular instance. It may in other areas of this zone, but right here, it doesn't reflect the character because there are so many other lots that are too small, have insufficient frontage, have homes close to the lot lines, etc. The second prong of the hardship test, if there's no fair and substantial relationship between the purposes of the ordinance and its application. So, why do we have lot frontages? For air, light, separation from neighbors, prevent overbulking and overcrowding, provide for stormwater treatment. Well, the lot does that because it has enough front lot line. It just doesn't have enough frontage on a street. And why do we have, I've got to go back to my chart here. Why do we have lot sizes? Some of the same reasons, but here, while they are smaller than the required amount, they are in keeping with the area. Why do we have lot depths? Again, some of the same reasons, to stop overbulking, to create separation of neighbors. The lots are 85 feet deep. That's not going to change. And why do we have front yard setbacks? Same reasons. Prohibit overbulking, provide for sight lines, air, light, etc. The house itself is only a couple of feet inside outside the building envelope, and the other items, steps and deck, are, if a variance is required, are low and are unobtrusive. So there's no reason to apply that setback here. And then same with rear yard. So for all of those reasons, there is just no reason to apply the strict requirements of the ordinance in these respects to this particular lot under these particular circumstances. The third prong of the hardship test is that the proposed use is reasonable. It's a permitted use, therefore the use is deemed reasonable. That's the V. Hudson case. And then finally is substantial justice will be done by granting the variance. And the test is, if there's no benefit to the general public that would outweigh the hardship to the applicant, this factor is satisfied. That's the Harborside case, it's a Portsmouth case. And any loss to the applicant not outweighed by a gain to the general public is an injustice. So we're looking for variance to create a comparably sized lot with comparable frontage and in many cases comparable setbacks to others in the neighborhood. The wetland buffer effect will be dealt with by the Conservation Commission and the Planning Board in a conditional use. So I submit is not the purview of this board. So we think this is good for the public. It's going to be good for some family to find a modestly sized lot and home in Portsmouth, while denial will take away a financial opportunity for the existing property owner, a financial opportunity for Phil as the developer, and a living opportunity for some family down the road. I don't know if these guys have anything they want to add. Apparently not. You didn't find that section. You weren't looking feverishly like I instructed you, but it's all right. So that's all I have, unless you have questions.
Thank you. Any questions from the board right now at this point? No. Apparently not. Thank you. Are there any other speakers in support? Anybody in support? Anybody present present who wish to speak in opposition? Yes, come up, please. Do we have anybody on the phone? Yes.
It's almost nap time.
Yes. Your name and address, please.
Hello, Fred McMullen. I live at 1000 Woodbury Avenue. And, my lot is adjacent to this lot. My frontage on my property, which I've lived there for 43 years, is on Woodbury Avenue. And honestly, I can't say I can figure this map out. I'm sorry, I just can't figure where I am, but it looks like there. The south side of my lot is what borders 22 Maple Street. And I have to take exception with this variance in all of the variances that are asked for here. Going down the bordering to my lot is going to be this new lot, and 30 feet setback is what the zoning is, and they want only to do 19. Leave me with 19, and I think that is a hardship to me. The lot is a kind of an odd shape because it's a long lot, but it's not too deep. I'm well familiar with that lot because I know when it was divided in the 1950s, and I know why. And it would have been a lot smaller than that had they not wanted to conform to the rules of Portsmouth. So it is that size. It is tough because it does have a sewer easement which runs through my property and through that property. And to the bottom of the lot or to the west, we have wetlands down there. The bottom of that lot, where the wetlands are, there are some substantial trees. Where I think they've laid out this house, they put 4 stakes in that we can see. That would be down into the trees. Over half of that lot is treed. And those trees down on that bottom end of that lot protect that wetland. They protect it from erosion, the ground from erosion, and they use a lot of water out of that wetlands to help the ecology of that wetland and all the neighbors that abut it on both sides. And the bigger thing, at least to our neighborhood, even although those two things are important, is that it's a natural barrier for the noise from the Spalding Turnpike and from the Pease Air Force Base. To lose those trees, we're going to lose that barrier. We can't go to the state and say we need a barrier. They're not going to put it way out on Woodbury Ave. It's not going to help us any at all. Those trees are a natural barrier. They not only help 22 Maple Street, but they help me. They help everybody in the neighborhood that's up our side. Very important. I know the builder says he's not going to cut any more of those trees than he needs to, but that sounds like carte blanche to me. And if they have to get a truck in there to do a job, they're going to cut the tree down. The tree's not going to come back. If the house is built in there, then the people who buy the house are going to come and say, those trees can't be over our house. We're going to cut them down anyway. So we're going to lose the trees. It's a lose-lose in either way. And I'll tell you what, there's some aspens down in there that are big trees. They're handsome. We really would hate to see those go. I'm sure they're old Frank Jones trees. So I think that's a hardship to the whole neighborhood for that to have happened. I want to say that I really disagree with dividing this lot in the first place. We have a nice conforming lot in the city. They want to put 2 non-conforming lots on the city. This really doesn't make sense. I can't agree with this. I don't think that's good for the neighborhood. It is going to help crowd the neighborhood, and we don't need that to have happen. There's no hardship in not doing anything on this lot at all. And the amount of good that small piece of property does for the whole neighborhood really outweighs any kind of building situation can possibly be figured out for this lot. I don't do this often, but I heard a lot of phrases like public welfare, won't help it. Property values, won't help it. Unnecessary hardship, I don't think the owner of this property has that unnecessary hardship. It's not going to prevent overcrowding, it's going to create overcrowding. There's a lot of water that comes down Maple. Maple is a slanted street, as this property is also slanted, and that water runs directly onto this subdivision that they want to make, and if you go there today, you'll see where it runs right down through there. There's going to be a problem there. The negative air and light, yes, of course it is. The neighbor directly to the other side of this, and he may speak, is going to be affected by both of those things. The fellow spoke on architects having obligations to the environment, and he's going to just destroy this one 100%. There's no question. And I don't think this is in the public interest at all. It's a small lot and does a land of good for so much and for so many people. For the current owner of 22 Maple and and the rest of the neighborhood, it will spoil what we have there, and it will be non-conforming. It can take a perfectly good lot and make 2 non-conforming lots out of it. I really object. Any questions, please?
Thank you. Anybody? Any questions? Apparently not. Thank you.
Thank you.
Is there anyone else present who'd like to speak in opposition? Anyone else in opposition? Come up, please, if you would.
Hi there. Hopefully you can hear me. My name is Sandra.
Oh, I'm sorry. Yes, your name and address,
My
please.
name is Sandra Penelakis. I live at 5 Meadow Road, right in the corner here.
Right?
Right here.
There.
So if you look at this map.
We need you on the mic, please.
If you look at this map, as Fred had already indicated, going from right to left, this is a hill. It's a hill. You're going downhill. And then you come around, you can see it says Maple Street, and there's 2 little lines that keep going forward. That's my driveway. That's how close I am. So for me, I have concerns of this from an intrusive level, where I'm coming right out of my driveway, and then now there's a house there, where right now it's just a hill that is partially cleared, and then we have the wetlands further towards the left, big trees, as Fred had indicated. I also have concerns about the sewerage on our road. I was talking to another neighbor that's adjacent to us that didn't make it tonight. She was indicating how much there's a lot of work going on up in that Maplewood area and Woodbury Ave, and our sewer system, Meadow Road itself, is stressed. And to add another house, so I have concerns about that. We live on a corner lot. My parents lived in the house that I'm in now before me. They were there for 40 years. Now my husband and I are there. And we love Portsmouth. We both grew up in Portsmouth, and this was an area I always liked this area. The tree line is great, and I just hate to see that whole area turned around the way it was, as far as two two lots, two postage stamps, if you ask me. That's what it kind of is going to end up looking like versus two bigger lots or one bigger lot like most of the rest of the neighborhood. Thank you.
Thank you. Any questions? Apparently not. Is there anyone else present who'd like to speak in opposition? Come up, please.
Go ahead.
Go after me, Tyler. Hi, my name's James Penelakis. I'm looking at the variances, and they want to take these variances and almost cut them in half. The back side of that yard, you're supposed to have 30 feet to your neighbor. They want to give him 18. The front to the road, you're supposed to have 30 feet. They want to give 15. The sides, the same way. Take that lot and cut that lot in half because it's a long lot. Again, you're making two illegal lots or two lots that don't accept what's going on. As far as the gentleman speaking about the lots, this lot they're trying to set up is comparable to what's going on around us. No, this lot is a lot smaller than the houses around us. And the thing is this lot is going to be cut. The house is going to be right there. You're going to have problems with the kids in our neighbor, if they put children in there. The other thing is this lot is being cut in half only for capital gains. These people just want to make money off this lot. That's why they're asking for all these different variances. Your setbacks go from 30 to 19, from 30 to 18. Your road frontage is from 100 to 82, I think. I can't. But this lot is going to be so much smaller than the lots around us. And these two houses on this lot are going to be so close together that I want to subdivide my house, subdivide my land. This property is just being split in half for capital gains. There is no hardship. There is nothing going on. It will do nothing for our neighborhood but make it look bad. And this house will not do anything as far as for a family, single dwelling. There's going to be a lot of problems on that street because we don't have the right setbacks. When the plow comes, he's going to drive his snow right into that guy's yard. That's how close they want to be to the road. This is only set up for capital gains. These people just want to make money off this lot, and they want you to make it two illegal lots, as I call them, and it's just not fair to the rest of us. We had to come in here to do setbacks for decks that were going to be 10 feet inside my house on the back side. Had to make sure we did the right setbacks. We wanted a pool put in the back. We had to make sure we had the right setbacks. We had to come in and do everything. To change your setbacks, it's just like saying to the town, saying to everybody around us, we can stick a house here. You can stick a house here. Got 3 houses down the end of Maplewood. They're so close together, you can actually see inside the guy's house. That's not the way Portsmouth used to be. You have to have some breathing room. And this lot will not do that for us. It's not going to benefit anybody but the person that wants to make money on this lot. I don't think it's right. We're giving up too much. Thank you.
Thank you. Any questions from the board? Apparently not. Thank you. Any other speakers in opposition?
How you doing? My name is Tyler Bradbury. I'm on 91 Woodlawn Circle. Concur with the prior two speakers. Just do a couple brief notes. I think this is pretty succinct based on the 5 variances that they fall short of. Boating into the idea that where we live in Portsmouth in the Frank Joe's neighborhood, I think this is a sheer attraction in terms of people living in this part of the city for reasons that it's not close to downtown, it's not congested, it has the allure where there's certain room and spacing to enjoy all that Seacoast has to offer. I first learned about this through some zoning personnel that was trudging through the back end of my property, and where I'm, a little bit old school, initially wished that this people would come and, introduce themselves face to face based on what they were trying to do here. It initially put me in a corner of discontent here about learning it that way. After it being certified wetlands and seeing problems that occur down between these properties that I abut to firsthand, this building will absolutely adapt that. There's pooling. It even causes further issues for the other two properties that are down on Woodlawn Circle as well. And really kind of considering where this variance falls short in 5 areas to have an adequate lot, what are the purposes of having these variances in the first place if we're going to be passing them if they're coming short time and time again? An additional building will absolutely cause further congestion, oversaturation for livable properties in a comfortable neighborhood, greatly impede the privacy for all surrounding neighbors within that general area of 2 neighborhoods. Building a new building in this lot is not something that is desirable or necessary for the Frank Jones neighborhood. I kindly oppose this and the rejection to divide this property in a small lot and jam one more building into an otherwise quiet and quaint neighborhood part of town, and appreciate your time.
Thank you. Any questions from the board? Apparently not. Any other speakers in opposition? Anybody? Any other speakers? Mr. Ziff? Mr. Ziff? No? Nothing? Okay. Last call for speakers. 2 for or against. Anybody? Oh, okay.
Just me, as you might expect.
You're all set.
Tim Phoenix again.
Okay.
I would point out that I didn't before, that Mr. Franciosa did attempt to speak to some of the neighbors. He did speak to Mr. Pantelakos, and he did speak to, was it Michael Prue who spoke with?
Excuse me. That was a conversation. He has no right to bring my name up onto this. It was a conversation.
I'll give you a chance to respond, sir.
You're gonna have a problem.
I just wanted to mention that he didn't go into this, blindly, lightly. He did try to reach out to some neighbors to have a conversation. They're obviously entitled to whatever position they want to take. He would be willing to offer Mr. McMullen a fence along their common property line if that would ease his concerns. The other thing, the section of the ordinance that I asked Eric to find that he couldn't, I found. And it's also, which I forgot, it's in my submission under footnote 2, and it's section 516.40 of the ordinance, which I also have here, provides that in the SRA and SRB zones, terraces, decks, steps, and stoops that are uncovered and unenclosed and are less than 3 feet in height and less than 100 square feet in area only require a 5-foot front and rear setback. So, in the chart, there's been concerns about the distances, and I brought some of this onto myself because I listed them, but just to be safe, so that the house is 27.6 feet in the front where 30 feet is required, but the rear actually meets it, and those other appendages, I'll call them, that Eric advises me are less than 3 feet in height.
Just,
don't
Tim, if I
apply.
could those are projections into the front yard. So instead of a 30-foot setback, it could be 25. So you could they could project into the 30-foot.
Oh, I read that wrong, yeah, okay.
So they could be 25 feet in the rear, in the front, but then.
Okay, well, I apologize. Thank you for correcting me. I thought it was reducing it to a 5 feet. So some of it would still apply, but part of it will not apply. The rest of it, I won't belabor it. We've made our arguments. We think this is a good project. In my opinion, those that have spoken against it just don't like it. I don't think that those, their reasoning overcomes the rights of the property owner. And Mr. Franciosa developed the property, which is in keeping with the size and characteristics of that neighborhood. That's all I have.
Thank you. Last call, 2 for or against?
Sorry about getting angry. Man comes to your house and wants to talk to you about what he wants to do as a casual conversation, then he brings it up like something's going on. The other thing I'd like to bring up is this gentleman is talking, he didn't put this in oh, this isn't right, I didn't 25 feet here, or I don't know if they really know what they want to do. But I'm explaining to you right now that that lot and that house that they want to build on is just not right. Setbacks, neighbors, all the neighbors I talk to do not want this up there. They don't want it in there. I can't speak for everybody because they're not here, but our conversations, even houses down the road, do not want that house there because it would make for a bad spot for a house to be built and cram two houses together. It's just, all our setbacks, everything they want is just shrinking that lot down to two bad lots. And I just think it would be wrong. He doesn't even know, he hasn't even wrote out, he's got too many of these things to say, well, I'm not sure about this or that. How do we know what we're getting into? They're not up front with us. He doesn't even remember the setbacks.
Address the board, please. Yeah, thank you.
Okay? He
Yep.
doesn't know what's going on. Thank you very much.
Thank you. Last call, 2-4 against, no speakers. Okay, we're closed on the public hearings aspect and ready for some discussion on the board. Does anybody have a thought to kick us off here?
Well,
Mr.
I guess
Lee, thank you.
to quote one of our former chairmen, I have some pretty serious heartburn about this application on multiple levels. You know, we're taking a conforming lot and dividing it into two non-conforming lots. Most of the house would be in the wetlands buffer zone, which is a huge problem no matter who makes that decision. So for those two reasons right there would be plenty for me. I would not be supporting this application.
All right. Who's got the next comment? Anybody? Somebody? Ms. Margison? Then Ms.
No, I was
Ms. Margison.
So I think I will be supporting this application. I think that it is, at first blush, a lot of relief to ask for. However, there's a lot of things about this that they really do meet zoning. In terms of open space coverage, they will exceed it. Building coverage, they are well below it. Hardship is always an issue for me. However, the applications have have persuaded me that there's a lot of non-conforming lots in this area, and I do not find that this lot is a new kind of configuration for that neighborhood. So I will be supporting this.
All right, thank you.
I do understand people's concerns over wetlands. I think that, a lot of the members here have concerns for that, but that is not within the purview of this board. That is within the purview of Conservation Commission and the Planning Board, and that's a separate process called a conditional use permit that we have no control over.
Thank you. Who's next? Ms. Eldridge.
I'm also inclined to support it because as I look at the lot here on the tax map, it indeed looks very much like too many of the other lots that I'm looking here in this neighborhood. And it's just not that much smaller. And I agree with Ms. Margison in terms of the lot coverage. There will be the required amount of open area around the homes. And again, we can't control some of it. We can't control the wetland. That'll be judged by another committee. The trees, I hope you keep as many up as you can. It's clearly important to your neighbors. But other than that, this just doesn't seem intrusive and seems more like the neighborhood than the current enormous lot.
Thank you. Anybody on this? Mr. McDonald.
This discussion and others like it tonight caused me to come to a conclusion that what we really have is a competition in each of these cases, a competition between private benefit and public benefit. And It's hard to say, for me, hard to say which one supersedes the other in terms of importance. People who buy a piece of property and pay for it are entitled to the use and enjoyment of it within the limits of the ordinances. The ordinances are there to protect the public. And I can't see any unnecessary hardship on this lot that would entitle the owner of the property to go outside of the ordinances of the city in order to maximize the return on their investment, because that's what they're doing. So, after thinking all that through until my head hurts, I'm kind of deciding that I will have to vote no on a motion to approve this application.
Okay,
That's
thank
it.
you. Thank you. Anybody else before I try to encourage a motion? Mr. Lee.
I'd like to add one thing. I think the fact that there are similar, or even if every lot in the neighborhood is non-conforming, that's not a valid reason to inject 2 more non-conforming lots in the neighborhood.
I'll throw it in there. We're looking for 5 variances. I have no problem with the lot depth. I don't think that's a big ask. Street frontage, it's 2 feet. The primary front yard or the rear yard, I really don't have any problem with that, as you say. There are a lot, 90% of all the house lots in Portsmouth are non-conforming. I don't think it's my job to create more non-conforming lots. You have a conforming lot. And, one lot is 2/3, the other lot's nearly half of what it should be. Granted, you're not going to find a lot of 15,000 square foot lots in the city of Portsmouth anymore to build on, but I can't see taking an existing conforming lot and making 2 non-conforming lots. Those are my thoughts. Thank you.
Okay. Okay. Mr. Lee? No.
Well, I'd just say for the reasons outlined before, I would move that we deny this application.
All right. The motion is denied. Do we have a second to that motion? Second? Anybody? Mr. McDonald? I think you got it. Okay. Mr. Lee?
Well, for
Okay.
reasons I've enumerated before, I think that the non-conforming lot, we have a non-conforming lot, so I really, no matter if every other lot in the neighborhood is non-conforming, that's not a valid reason to inject 2 more non-conforming lots into the neighborhood. It only has to fail on one of the requirements, and I think it does that. So for those reasons, I would move that we deny this application.
Okay. Mr. McDonald?
Well, first of all, I agree with Mr. Lee entirely. And I would just say that if we keep granting variances to the ordinances, then there will be more properties in Portsmouth that fail to comply than those that do comply. And then we can just throw the ordinance book out the window because it won't matter.
Okay.
Excuse me. And I'm going to say, if you don't believe in granting variances, you probably shouldn't be on the zoning board. I mean, it's what we do. We judge them, but we do them. It's kind of that we have to believe that there's a reason for it. And you don't this time. And that's fine. But
Mr. Chairman?
it's what we do.
Oh, yes.
May I reply?
Please do. Yes.
I don't think the mission and purpose of this board is to grant variances. I think it's to
Sometimes.
evaluate land and building use in the city to make sure, to the extent we can, that it's appropriate to the city's vision of where it wants to go.
Yes, appropriate. Sometimes it is, yes.
Sometimes, but
Yes.
not always.
Yes, I agree. You've seen me vote no, yeah.
Okay.
Could I just get a point of order on what
Sure.
criteria? I didn't.
We don't have.
Was it
Follow.
On 5?
I didn't say, let me.
No, yeah, we'll get to that. Yeah, I agree.
Well, number one, the variance is not contrary to the public interest. Part of the criteria here is it can't injure public rights. I think in this case, the benefit to the applicant is outweighed by harm to the general public. And that's two, you only need one.
I will add that I have struggled to try to find a hardship in the lot, and I got to admit I don't find one. It's oversized somewhat, but it's a perfectly good lot in terms of total size. It's got some very special characteristics, as we heard about it, being wet on a slope and supporting some very large trees, which serve very good purposes, obviously, which trees aren't protected by the ordinance, I know that, but they are very important to the neighborhood, and that does relate to the character of the neighborhood, in my judgment anyway. So I have when I first read this, I said, yeah, that'll be an easy one, I can support that, but the more I thought about it and looked at it, I decided it doesn't present a hardship. It's a perfectly adequate lot in terms of the dimensionally, and it does, as we heard, serve a real public purpose, if you will, by having it's a drainage area apparently, and supports large trees, which help with drainage as well. So for all of those reasons, I will be supporting the motion, and my particular concern is that it simply doesn't present the hardship that I would be looking for to vote for it, which I'd like to do, but I can't. So, having said all that, the vote is to,
Mr.
with
Chair?
respect to is to deny. Yes.
So I
Ms.
just want to
Martin.
point out that the applicant's application was that a hardship may be found where similar nonconforming uses exist within the neighborhood, and the proposed use will have no adverse effect on the neighborhood. And so that's very different from our traditional analysis of hardship, in that we have a neighborhood where there is a lot of existing nonconforming lot sizes. And, you know, therefore, I think that they have met the hardship criteria under that, if not under our traditional criteria. And, you know, I find this use reasonable. It's in the single residence B zone. And I don't find that anything that would be put into that lot would be any different than what is there now.
Okay.
And I think that, frankly, we're getting this wrong.
Okay. Anybody else, any final thoughts? No, apparently not. Okay, the motion is to deny, and we'll start down there with Mr. Mantle.
Yes.
Yes. Mr. McDonald?
Yes.
Yes. Mr. Lee?
Yes.
Ms. Margison?
No.
No. Ms. Eldridge?
No.
And I vote yes as well. So the vote is 4-2 to pass the motion, which is to deny. So, okay. First non-unanimous vote tonight. Does someone have a motion? Oh, I'm sorry. And I said that before and I forgot it. Yes, we have one more item. Peter, that's
So,
yours.
We're working with the
So is she.
New Hampshire Municipal Association to
Like your hairdresser.
provide some training.
Hi, Steve. Oh, sorry.
we're working with the New Hampshire Municipal Association to provide some training for the board, and we're looking at September 27th, which would normally be our second meeting. However, we already have a lot of applications in for September, and the deadline's not for another 2 weeks, plus with the rehearing of Banfield. So I might put out, I'm going to reach out to Stephen Buckley, who's the attorney, who would be doing the session, and I'm going to look for some alternate evenings maybe, and then I'll probably send out a poll to the board members to see what works. But hopefully maybe in the end of September, or if we have to push it to October, but I just want to give you a heads up.
How long would you expect?
He was thinking a 2 hour, so he would give some presentation and then also have some questions from the board. And it's actually a good timing because we have this new legislation that is coming, and we should expect a memo from our legal department about that new legislation, which takes effect August 23rd. So it'll have to do with how we make our motions. They're probably going to have to be more detailed, finding of facts for each criteria. So,
okay.
But we should have something. So just to give you a heads up about probably just like a work session on a night that we don't have any other business.
I mean, this would be an informal around the table.
And even if we
good.
have to be in conference room A or something.
Yeah.
If there's something else going on in here.
Okay,
But-
I mean, this isn't, we're not going to sit there and listen to a lecture.
It's 2
I mean, it's
hours,
more
we
like
can
a-
do
more
it.
like an
Right,
interactive session.
right.
Yeah, okay.
There might be a little lecture at the beginning. But
Could we order pizza now?
Right. So,
We
I've been to
should.
some of those
We have
shows
to have
with the state
refreshments.
people.
right. We'll see what we can do.
Okay.
All right.
Does someone have a motion?
Motion to adjourn.
Thank you. Mr. Mantle, thank you. Second.
Yes,
Second. Those in favor, please say aye.
Aye.
Aye. Adjourned. Thank you. No opposition.